Yes, Mr. May I seek an indulgence, because an appeal is fixed on Monday, but I will not be available. Kindly accommodate me for a week. When it is called, we will see.
Inclusion in content and matter matters. Inclusion of content matter.
Bearing connection.
Okay.
Bearing
My lord, may I have your lordship's leave to mention this FMAT matter, my lord, for inclusion.
Next day.
Next.
Yes.
Item number 1. Arising out of an order, my lord, passed, my lord, on a chapter 13A, my lord. Initially, an order under chapter 13A was passed, my lord. There was a conditional leave to defend, my lord, in eviction proceedings of a payment of rupees subject to payment of monthly payment of 4 lakhs. Now, my lord, it went up to the division bench, my lord. The division bench, my lord, set aside modified the portion of the order, and Miller gave unconditional leave to defend under Rule 3, Miller. The matter went up before Miller, Rule 9, Miller, before the Honorable Supreme Court. The Supreme Court again modified, Miller, the order, Miller, and passed, Miller, a order conditional leave to defend, Miller, on payment of rupees, Miller, 2 lakhs, Miller. Miller, they did not pay. It was passed on the context of Chapter 13A, Rule 9, Miller. Miller, we filed an application before this court because it's a conditional order, Millard, for Millard obtaining a decree because there's a default. Because the initial Honorable Single Judge's order, Millard, had a default clause. Millard, that was modified. Supreme Court did not, Millard, say anything on the modified clause, Millard. Millard, I filed an application to such effect. The Honorable Single Judge was of the view, Millard, since the default clause has not been reimposed by this Honorable Supreme Court, Millard, law will take its own recourse, Millard. So, Millard, he cannot pass a decree for eviction. This is where is, Millard, the case is, Millard. But Lordship has to take the order in the context of Chapter 13A, Rule 9, Millard. Also, Millard, with the principles of Millard, Order Millard 37, Rule 3 of Millard, the code in question. If your Lordship takes the impugned order once.
Chapter 13, if conditional right to defend is given,
yes,
condition not complied with, is right to defend goes. Will that be an automatic decree? Because irrespective of the defense,
yes,
the plaintiff has to prove its case.
Millard, that Millard, if I'll just put it in this way.
So an automatic decree in the absence of a defense,
yes,
has to be read in the light of the primary burden of the plaintiff to prove its case.
Millard, only one thing, there is a conditional leave to defend, there's a non-compliance.
Correct. Non-compliance, what is the consequence of a non?
Yes.
Consequence of a non-compliance is he has no leave to defend. Correct.
And Millard, our rule, subject to correction, Millard, provides that Millard, the court doesn't, Millard, loses its jurisdiction. You have to apply and get appropriate orders. I have applied for getting appropriate orders that has not been given.
Appropriate order is like an undefended suit. You defend, you prove your suit and you get the decree.
Millard, kindly have a look at.
He will not have a right to defend.
Millard, that the Honorable Judge has not said anything, Millard. He said law will take it. Yes.
The right to defend
that is
no longer subsists.
Millard, that he also knows.
But the burden to prove the case is not absolved.
Yes. Millard, only one thing, their Lordship has to take a second view, Millard, subject to correction. The second argument.
Let us say there is a money decree sought.
Yes.
Which is barred by limitation.
Yes.
Now, if the defendant does not have a right to defend, will the law relating to limitation get
No, that is not the case. That is all the Supreme Court also says. There was a conditional leave to defend upon, if you don't comply, there will be a decree of eviction. Right. That order was there.
Decree of eviction subject to you proving the case.
No. Initial order of the Honorable Single Judge had that clause. Right.
We are reading that clause in light of the requirement of the plaintiff to prove its case.
In a Chapter 13A, Millard, perhaps subject to correction, Lordship will correct me if I am wrong. That is not the case. This honorable single judge already passed that order that if he doesn't, Millard, pay, there will be, Millard, and decree. Kindly, Millard, have a single honorable single judge's order. I'll, Millard, only Millard takes Millard the single. Page number 41 of your lordship did, lordship's brief, Millard, order of 28th of February 2017. That is, Millard, page number 41 of your lordship's brief. First, I show the ordering portion and then I read the judgment, Millard. It's only the relevant part, not the entirety. Lordship will kindly take, Millard, page 50, Millard. 50. দাঁড়া এখান থেকে এটা অর্ডারিংটা দেখিয়ে তারপর দেখা I therefore grant the defendant conditional leave to defend the defendant upon payment of occupational charges at the rate of rupees 4 months on and from March 2017 till the disposal of the suit shall be entitled to defend the suit. The occupational charges for the month of March 2017 shall be paid by 10th March 2017 and the future monthly occupational charges shall be paid by 10th of each succeeding month. Upon payment of occupational charges for the month of March 2017, the defendant shall be entitled to file written statement within a period of 4 weeks from the date. In default of making payment of monthly occupational charges for the month of 2017 or any future monthly occupational charges, the decree for khas possession shall automatically follow and for which there shall be no need to apply afresh. This was the order. So there is a default clause. Chapter 13 provides for it. The Honorable Single Judge has provided it. Now, Miller, there are two consequences. If you pay rupees 4 lakhs a month, you put in the written statement and you get a chance to defend the suit. If you don't, then Willard, written statement obviously cannot be taken into account and Willard, the decree of khas possession would be followed. The matter went up before the Honorable Division Bench. Kindly have a look at the ordering portion of the Division Bench, page 52 at page 62. That is, Willard, 22nd of Willard, August 2018. Kindly have a look at, or Millard, kindly have a look at page 64, Millard. Or I better place it, Millard, from the last portion of page 63. Having considered the pleadings of the parties filed in the suit, it is expressly palpable that the respondents' plaintiffs claim that the appellant defendant's occupation in the suit premises was a single tenancy, which has been determined by a service of notice under section 106 of the Transfer of Property Act, while on other hand, the appellant defendants plead that there are two tenancies in the suit property. Neither party has referred to any written agreement regarding creation of the tenancies. Therefore, the controversy should be adjudicated upon the oral and documentary evidence which cannot be summarily decided in a proceedings under chapter 13A of the original side rules. In the appellant's defendant's claim, the applicability of the provision of the Transfer of Property Act, the validity of the determination of the tenancy and pecuniary jurisdiction of court are involved. Thus, the defense on which such law cannot be termed as bogus or moonshine or no defense at the primary stage of the suit. In this context, one may take notice of the observation made by this court in a recent judgment passed dated such and such, passed in Newman and Apollo Zipper. Beside this, the respondent needs to use two letters as the vital piece of evidence in support of the case of the plaintiff have been challenged by the defendants upon appearing affidavit with the contention that the same are forged and fabricated. Such a defense cannot be treated as a weakly and flimsy and evasive defense, which a stringent condition should be imposed upon the appellate defendant to place such a defense for trial. The affidavit of the parties, it can be said at this stage there was a relationship of landlord and tenant between the plaintiff and the appellant defendant in respect of the tenancies of the authorizing appellant defendant's occupation of 9725 square feet of the properties at a contractual monthly rent of rupees 12,000 and odd. There is no claim of the respondent that before the alleged determination of any steps were taken to enhance the rent. As such, it cannot be said that the defendant has no defense. It is not proper for the court to fix an exorbitant amount of occupational charges payable by the appellant. A precondition under chapter 13A was defense of the suit. Now, Millard kindly omits, Millard, the next paragraph. In conclusion, We find the last paragraph hold there is a good defense of the appellant for contesting the suit. To use such a defense, the appellant need not be burdened for a lump sum of rupees 4 lakhs a month. Impugned judgment is required to be modified. We do modify it by granting unconditional leave to defend the suit. Accordingly, appeal is allowed. And Miller, this is cross objection dismissed. Now, Miller, appellate report has been subsequently judgment, which was the sheet anchor for passing, has been subsequently set aside by the Supreme Court, granting Miller a decree of eviction. Miller. So that now Miller Supreme Court order in the present case, Miller, is at page 66. The next page, Miller. The instant appeal are directed against the order dated 22nd of August 2017 passed by the High Court, whereby the High Court allowed the appeal filed by the respondent and the proceedings granted them an unconditional leave to defend the suit for eviction filed by the appellant. The Miller Supreme Court is cautious. The plaintiff appellant has filed suit number 142 against the response for eviction from the premises after serving a notice under section 106 of the Transfer of Property Act. The appellant thereafter moved an application under Chapter 13, Capital of the original side rules for final judgment. The learned single judge video order dated 22nd of February 2017 had disposed of the application by grant of conditional leave to defend the suit subject to the respondents paying occupational charges per month from 1st of March 20 the disposal of the suit. Agreed the respondent preferred an appeal before the Honorable Division Bench of the High Court at Calcutta. The appellant has filed a cross objection which has been dismissed via the judgment dated 22nd of August holding that the cross objection not maintainable. The impugned judgment was allowed, appeal preferred by the defendants, thereby granting them unconditional leave to defend. Now, Miller, kindly takes Miller para 7, bottom of page 67. Having regard learned counsel for the parties and having perused the record, we are of the view for the ends of justice, if the respondents are directed to pay rupees 2 lakhs per month as use and occupational charges rent for the premises with effect from 1st March 2017. We accordingly we order accordingly payments made would abide by the final outcome of the suit. That is all the Supreme Court has done, Miller. So, Miller, what was the conditional leave to defend with a default clause by the single judge? 4 lakhs have been made into 2 lakhs. So, Miller, I applied to the court, Miller. They did not pay. It's in Robindra Sharoni, Miller, 9,000 square feet. Property, I applied, Miller, for Miller, for appropriate degree, for appropriate orders under Rule 10, Miller provides so, Miller. For an argument's sake, Miller, if your lordship takes Miller, Supreme Court specifically did not refer to the default clause. It refers to the order of the single judge and the division bench.
It says abide by the final outcome.
Final outcome, Miller, for mean profit.
The final outcome.
Mean profit, Miller. I have a mean profit against him, Miller. Claim for mean profits. That is there in the suit. I am entitled to an eviction decree if he doesn't pay. Otherwise, the order becomes meaningless in the section Chapter 13. If your lordship kindly have a look at
Khas possession decree.
Khas possession decree. Kindly have a look at Rule 9. Rule 9, Miller, of Chapter 13. Miller. Kindly have a look. Miller, may I give one more copy, Miller? Ache.
Chapter 13 or order 37.
What is chapter 15? Item OG. So sham dispute things.
Chapter 13 is like Miller, order 37 suit, Miller. Akin to it, in order 37, there is a distinction. There, Miller, if there is a default in non-compliance, the decree automatically follows. In Chapter 13A, one has to, that's the reason the single judge put in the default clause, one has to apply under Rule 10. Or, Miller, one has to ask for consequences. If your lordship takes Rule 9 and Rule 10 of Chapter 13.
In case of can put condition.
Also, lordship, kindly have a look at Rule 6, Miller. Court can impose condition for defending the suit. So, A, if he doesn't put in the security or Miller complies with the condition, his written statement will not be taken into account. B, if he doesn't comply with the condition, there's a default clause, I am entitled to a decree. My learned friend's contention, the affidavit, the Supreme Court did not give you expressly default clause, so I am not entitled to, you are not entitled to maintain this application. That, Miller, the order has to be read in context of Chapter 13A, Rule 6, Rule 9, Rule 10. Order 37 to the NHO. Rule 6B. CPC NH.
Quick pronounce judgment.
Because Lordship knows, my lord, in a chapter 13, in case of SAM defenses, I'll show, my lord, the single judge's order, my lord, where the single judge says that there may be a rare of flickering hope at the end of the tunnel. So I am giving you this leave. And this is also accepted by the defendant that the composite tenancy suits can be filed, my lord, clubbing the rent for the purpose of filing a suit. I'll, my lord, show in detail, but in overview, my lord, this is the case. Rule 6, Rule 9, and Rule 10, Lordship will take, my lord. Yeah. The sham defense, this is, my lord, automatic decree. বলছি
Finally. Abide by final outcome of this. Suit expeditious. Yeah, leave to defend not allowed. Rule 6 says automatically the judge will pronounce the actions. That is rule 6. But here, defense was not allowed. Man. It was a conditional. Rule 6, Mr. Ghosh, applies when there is a unequivocal refusal.
Yes.
Refusal to give leave.
Yes. Yes.
Right.
Pronounce a judgment, my lord.
When?
Correct.
When there is an unequivocal
Correct.
refusal.
Correct. Lordship is absolutely correct.
What happens when there is a conditional?
That, my lord, Lordship will kindly take Rule 9. With me, Lordship reads Rule 9, my lord. I said, my lord, Rule 9. Leave to defend. Leave to defend may be given unconditionally, which was not granted initially,
Right.
or subject to the terms giving us security,
Right.
or time, or mode, or
of-
trial, or otherwise. So
or
any
mode of trial.
or the mode of trial. Here is
If you see, the single judge's order is a conditional leave to defend.
yes,
What is the conditional leave to defend? Put in the occupational charges, and if you put in the occupational charges, it goes for full trial. It goes for full trial.
absolutely
If you don't put in the occupational charges, automatic decree will be.
correct, Lordship.
No further need to apply under Rule 10.
Correct, my lord.
End of story. Division bench is full-fledged trial.
Correct.
There is not a moonshine defense. There
Correct.
is a strong arguable case
Yes.
with regard to a nature of tenancy,
Yes.
no validity of notice,
Yes.
etc. etc.
Correct, my lord.
Supreme Court says deposit this amount as occupational
Per month.
charges and full trial. And full trial.
My lord, kindly have a look.
Because you see the two words. Thereafter, the judge will hear the case
if he-
expeditious.
My lord, if he
If it
doesn't
is an
come,
automatic decree on default, then the direction for hearing expeditiously does not arise.
my lord,
Now you may argue then what is the consequence?
consequence.
Consequence of default in our understanding. This says
Correct,
Mr.
Miller.
Ghosh just
No,
first
no,
blush.
no, absolutely.
First blush, not
Lordship is
clear.
speaking out, my lord, I also get my
First blush is, it is like striking of defense. In an eviction suit under 7.2.
772.
7.2.
Absolutely.
Striking of defense.
Yeah, absolutely.
Your defense is struck out because of non-payment of the occupational charges. Now you prove your suit and get the decree.
My lord, come to court and apply for a decree. The learned judge, my lord,
This
could
is
have-
our reading
Milord.
on the first.
my lord, kindly take, my lord, the order of the single judge gets merged. The Supreme Court is not, my lord, concerned, my lord, was not aware, my lord, or my lord was thought that he will comply.
With respect, Mr. Ghosh, I was sharing with my brother, the Supreme Court was dealing with this more in the nature of a striking of defense rather than chapter 13A.
My lord, the learned judge,
The
my lord,
requirement of chapter 13A in recovery of first
immovable-
possession
first position.
is an unique feature of the original side.
This is also there, my lord.
Order 37, if you see,
Order 37.
Order 37, there is no, it is generally for money decree.
Money decree. Now, my lord, judgment upon admission, lordship will also see in a 106 notice. If you have received the notice, Supreme Court is passing, my lord, a summary decree on its judgment upon admission. My lord, receipt of a notice can never be an admission, but Supreme Court treats this as an admission. Now, my lord, I had applied. My lord, the consequence, my lord, yes, I have. May I hand up, my lord? Kindly have a look. Rules 636B, my lord. Kindly have a look at, my lord. This is the distinction. Yes, Order 37, Rule 36B. Lord साहब के दिन
See the two words.
Yes,
I would say first see 6A
yes, yes.
and rule 6.
Yes.
No leave, automatic judgment.
Yes.
Rule 6, chapter 13A. Entitled to judgment for it. Entitlement to judgment.
That is the reason I pointed. This is the
Is-
distinction.
Just see the word, we don't know. Entitled to judgment and forthwith pronounced judgment. One is entitled to judgment forthwith if other requirements to deliver a judgment are made up. You may leave. 2 minutes. No, you may leave. It's all right. Other requirements of the judgment, we don't know whether the word entitled to judgment forthwith and forthwith pronounced judgment will get the same connotation or not. Pronouncement of judgment is only when he is entitled to. But pronouncement means there is no other discretion left in the court.
The court.
What to pass a decree?
Absolutely.
What to pass a decree?
That's the reason I said, Miller, this is the distinction between the Miller two statutes.
What to pass a decree? Here, the plaintiff shall be entitled to judgment for. Or in other words, the court will look into the plaintiff, look into the documents, and if the materials before the court are sufficient to establish and prove the cause of action, the court will pass it.
Absolutely.
So there is a degree of application of mind
Left to the court.
left to the court and a onus on the plaintiff to prove its case. Then comes if it is permitted to defend as a whole or part of the claim, the judge may direct him to give such security and within such time may be fixed, and that on failure of such security or time to carry out such direction as may be given by the court, or the plaintiff shall be entitled to judgment forthwith. The words are entitled to judgment.
Yes. Here under Rule 10, I have to apply.
And
here under Rule 10, I have to apply if there's a non-compliance, because the court doesn't lose jurisdiction of the Miller's original side rules.
yes, in all such cases, the judge shall have the power to give directions
Yes.
as to further conduct of the suit.
Further conduct of the suit. So, Millard, Lordship has to see, Millard, what is the conduct if there's a non-compliance.
This is where
The distinction is.
the honorable single judge, when gave leave to defend under 9,
Yes. First
gave
order.
a further direction with regard to
Yes,
the nature of
yes.
the conduct of suit.
So that is given, Millard.
The mode of trial he is entitled to.
Yes.
And
Mode of
he
trial.
exempted the mode of trial by saying give a
Conditional.
pass a decree.
Pass a decree.
Pass a decree. This goes up, and in the division, in the Supreme
Supreme Court says conduct of
Court.
trial subject to payment, Millard.
trial subject to payment. So when it says conduct of trial
Subject to, if there is no payment, Millard, I come and apply to the court. Millard, the honorable single judge should have decided this issue. What would be the mode? The written statement is on board. Whether he gets a conditional, it's Millard, his defense is struck out, or I get a decree. Millard, he should have decided, because I had paid for a higher relief, that I want a decree. He could have watered it down and said his defense has is struck out.
should defense is struck.
He has not said so. Kindly look at the impugned order. Law will take his own course.
Law
Will take his own course.
Law will take it. That is a good word.
Kindly have a look at the impugned order, Miller. There is some consequence. Now, Lordship, when I was in college, Lordships were in the 90s, were in the college. We knew the concept of mean profit person is not entitled to before he gets a decree, because it's a nature in claim of damages. Now in 2024, Supreme Court says in all pending eviction proceedings, you file evictions if the rents are very low. In a Calcutta case, we are going from
Profit will be given.
mean profit as per the current market rate.
In every case.
In every case, I have that judgment. I'll show. So, the law is never. It is moving on. So we had the concept, mean profit is a concept like
After
damage.
decree.
Millard, even I had an occasion to argue and assist Millard that you can't get mean profit. I'll go the contractual rent. I'll go till you get a decree against me. Now, Millard, it says, Millard, even in a statutory tenancy, Millard case, Millard, you apply for the market rate and the court will take, Millard, grant mean profit. This is the current 2024 view. In today's scenario, Millard, in this, Millard, law will take its own course. Perhaps, Millard, is a judge.
Just
Let
place the single.
kindly take the judgment, Millard,
What
of the
we
impugned in the
proposed,
present.
Mr. Ghosh, what we propose to decide, consider is, if you see the judgment of the Supreme Court, the intention, the purport of the judgment is not as harsh as the
Millard, you can
honorable
defend the
single
suit.
judge's view.
You can defend the suit I had followed,
First
provided
and foremost, if he has failed, he has his right to defense. His defense is struck off.
the written statement cannot be looked at.
And the entitlement to the decree in terms of Rule 10,
Yes,
in
grateful.
terms of Rule 10 would be in a manner where the plaintiff has to discharge its onus.
And his defense is gone.
Defense is struck off. No defense. But he is entitled to argue.
Argue and cross-examine only my witness
Cross-examine.
on my document.
Oh, yes, not on independent evidence.
Not on
He
my
cannot
document.
tender a
Absolutely.
document.
That is also, Millard.
Simple.
This is
That, in our
1990.
understanding, this is what the Honorable Supreme
Supreme Court
Court
meant.
sort of meant, because what the words trial to be disposed of expeditiously upon payment is a full trial. However, if it is not upon payment and the automatic decree not being adverted to, correct, as a clause in the Supreme Court judgment, there is a merger. So we would be loath to bring it to that status but keep it at the stage where the plaintiff is entitled to the degree, not automatic to the degree, but entitled to the degree upon proving its case.
And his
Onus
defense
of the
is
case,
absolute.
right? Why we say it is a valuable right of possession is being taken away by the degree, recovery of possession and the condition precedents of notice, etc. It is for the plaintiff to establish.
Millard, two things, Millard. Lordship will look at the trial. So, Millard, the trial court, when I apply for a higher relief,
So you are in agreement that striking of defense is
Millard, strike of defense is a condition, but if your Lordship, if Lordship takes order 8 rule 5 principles, Millard,
so that you can apply and get your degree on those
kindly
principles.
takes Millard the impugned order once. Kindly take the impugned order. Impugned order doesn't Millard say at all. Kindly takes, I'll not list the entirety, Millard. I've marked the portions, Millard. Kindly have a look at the findings, Millard. Page 93. The issue in the instant application whether the order passed by the Honorable Supreme Court directing the defendant to pay rupees 2 lakhs per month as use and occupational charges for with effect is a conditional order or not. So this was my argument. It's a conditional order. Millard, page number, if your Lordship takes 93, the Millard in last paragraph.
Yes.
I just placed the findings, Millard. The order starts from page 87. Kindly have a look at page 93.
Right.
The issue, has Lordship found?
Yes.
The issue in the instant application whether the order passed by the Honorable Supreme Court by directing the defendant to pay rupees 2 lakhs per month as use and occupational charges stroke rent for the premises with effect from 1/3/2017 is a conditional order or not. So if I succeed before I have lost, it's not a conditional order, he says. If I succeed, it's a conditional order, then consequences follow.
Consequence.
Now, Millard, chapter 13A, page 94 has been quoted. Millard, the Honorable Judge doesn't quote Millard, Rule 10. That is also, Millard, necessary for this purpose. Now, in the order passed by this court in GA number 2883 of 2013, dated 20th of February, leave was granted to the defendant to defend the suit upon payment of rupees 4 lakhs per month as occupational charges for the month of March 2017 and for the succeeding month. In the order, it was also made clear that in case of default, the decree of khas position shall automatically follow, for which there would be no need to apply afresh. The order passed by this court was modified by the Honorable Appellate Court and granted unconditional leave to defend the suit. The Supreme Court directed defendant to pay rupees 2 lakhs per month as occupational charges for rent of the with effect from 1/3/2017 and the payment would abide by the final outcome. Then judgment of Kiranmoy Dashi, the illustrious case has been quoted. Lordship,
Please read that judgment.
yes, we have it, Millard. Lordship, I'll give.
No. What is Lordship?
Yes, I'll read the judgment. In the judgment of Kiranmoy Dashi, this court held from the above authorities the following proposition may laid down with regard to the application under order 14. If the defendant satisfied the court,
judgment on admission.
yes. If the
Supreme
of the Supreme Court rules, Millard. It's 14 of the Supreme Court rules, Millard. Order 14. If the judgment satisfied the court that he has a good defense to the claim on merits of the plaintiff is not entitled to leave to sign the judgment and the defendant is entitled to unconditional leave to defend. If the defendant raises a triable issue indicating that he has a fair or bona fide or reasonable defense, although not positively good defense, the plaintiff is not entitled to sign the judgment and the defendant is entitled to unconditional leave to defend. If the defendant discloses such facts as may be deemed to be sufficient to entitle him to defend, that is to say, although the affidavit does not positively and immediately makes it clear that he has a defense, yet such a state of fact as leads to the inference at the trial of the action, he may be able to establish a defense to the plaintiff's claim. The plaintiff is not entitled to judgment, the defendant is entitled to leave to defend, but in such cases, the court may in its discretion impose a condition as to the time or mode of trial, but not as to the payment into court or furnishing of security. Next, if the defendant has no defense or defense setup is illusory or sham or practically moonshine, There, ordinarily, the plaintiff is entitled to leave and sign the judgment, and the defendant is not entitled to defend. If the defendant has no defense, E. Millard, or the defense is illusory, sham, or practically moonshine, then although ordinarily the plaintiff is entitled to leave and sign the judgment, the court may allow the defense to proceed if the amount claim is paid into court or otherwise secured, and give leave to the defendant on a condition, thereby showing mercy to defendant by enabling him to try and prove a defense. So this is Millard, we fall under E. Millard. As for Millard, the orders of these courts are concerned, Millard, up to the Supreme Court. Next page,
Supreme
Millard.
Court, Mr.
Lordship.
Does the Supreme Court hold that his defense is there is
No,
no
no,
defense?
Supreme Court doesn't hold. Supreme Court says we only modify the direction of the trial court by
Not trial court, the appeal court.
appeal court.
So the appeal court has held
Yes,
there is a tribal.
tribal issue.
So can't we say that he falls in C?
Millard, C, if it is C, Millard, then Millard, it's a payment to court. It's not a payment to me, it's a payment to court. Subject to correction.
And here it is a payment to you.
Payment to me.
All right.
It's a payment to court. If he's in C, it's a payment to court. Like for defending a money claim, Millard, I may show
Deposit
something,
that amount.
deposit the amount in court. If it's C, it's payment to court. If it's E, it's payment to me. From unconditioned to condition.
Right.
Supreme Court says that it's a payment should be given to me.
Right.
Now kindly take Millard the next page. In the order dated 20th of February 2017, this court held that the defendant appears to have raised some defense, although weak, and may or may not succeed at trial, given the opportunity to fight out the rest of the battle. The said defense falls short of moonshine, but little probable, and granted conditional leave to defend. This, Millard, subject to correction, Millard, as an advocate, Millard, I must say, it's Millard, the division bench has said something else. As Lordship says, Millard, he has. Now, Millard, the division bench, that is exactly, Millard, what
is the single bench's observation.
yes, the division bench is just below, Millard.
Ah.
He has quoted it, no difficulty. The division bench, while deciding the appeal, held that Millard I have already placed, Millard, I am not placing it again. The Honorable Supreme Court, while deciding the special leave petition filed by the plaintiff, held a number of issues and conditions have been raised by the plaintiff, which the Supreme Court do not proposes to decide, as a civil suit is pending and has not decided, then the payment made would be abide by the final outcome of the suit. So, Millard, there is a condition for payment. Now, Millard, kindly takes page 97, Millard. As per Rule 9 of Chapter 13A of the original side of this code, leave to defend may be given conditionally or subject to the terms as to the given security, time, or mode of the trial, or otherwise as the court may think. In the case of Kiranma Idasi Supra, this court held that if there is no defense or defense of illusory, sham, or practical moonshine, then normally the plaintiff is entitled to leave to sign the judgment. The court may allow the defense to proceed if the amount claimed is paid into the court or otherwise secured, and give leave to defendant on the condition, thereby show mercy to defendant, enable him to prove a defense. In the instant case, court, while granting conditional leave to defendant, opine the defense raised by the weak and maybe not succeed, but the division bench held there is a good defense or the defendants for contesting the suit. The Honorable Supreme Court, for ends of justice, directed defendant to pay rupees 2 lakhs per month as use of occupational charges from 1st March 2017. In paragraph 7 and 8 of the affidavit in opposition of the instant application, defendant has taken a specific defense that the petitioners are the landlord in respect of 9,725 square feet in the ground floor, and there are two separate tenancies. The east tenancy is governed by the west. The monthly rent of rupees less than 10,000, notice to quit is issued, is backed by law. So this is Millard, this affidavit. The initial order passed by this court dated 20th of February, it was specifically stated in default or making payment of the occupational charges for month of March 2017 on any future monthly occupational charges, the decree of shall automatically follow, for which it will not be applied. But the Honorable Supreme Court, while disposing of the SLP, preferred by the only directed defendant to pay per month with effect from 1st of March 2017, has not imposed any condition, penalty, made any condition. In the order passed by the Supreme Court, it was also clarified payment made will be abide by the outcome of the suit. In view of the above, court is of the view the order passed is not a conditional leave to defend the suit. Look, this is erroneous, subject to correction. This is in context of chapter 13. Consequence of non-compliance of a condition has different connotation, either a decree or striking out of the defense or how. But this is not a conditional leave to defend the suit, Millard. With deepest of respect, Millard, it is erroneous. Now, Millard, courts have held in what context the order was passed, Millard, on what application nature, Millard, that should have been said. The Honorable Supreme Court has passed the order for ends of justice. If the defendant has chooses not to deposit them, same would be an additional ground for the plaintiff during the trial of the suit. Millard, this is my application. He has to decide whether, Millard, he has a defense or no defense, or Millard, he cannot say it's not a condition.
After the Supreme Court order, what application did you take out?
Kindly, Millard, take. I Millard filed. It's according to me, it's a default. I want a decree. Millard, if he says this is not a decree, then what is the effect, Millard? That because my prayer was for a higher relief. Kindly, Millard, takes my application.
According to you, this application is under Rule 10.
Millard, my application, Millard, is kindly take, Millard, page 10, the prayers of my application. I had asked for a decree of eviction because according to me, that was a default clause. It's a merger with the Supreme Court order. If it is not so, then Millard, there may be, Millard, I would get a lesser relief, Millard. But he cannot say, Millard, it's not a conditional leave to defend. Because it's a condition which has been reimposed. Maybe, Millard, that stringent thing is not there. Stringent thing. Kindly have a look at paragraph, prayer, Millard, at page 10 and also paragraph 9. Para 8 and 9. If your lordship takes page 9 of my application, even though the said order, paragraph 8, page 9, passed by the Honorable is in presence of the counsel of defendant till the defendant has not paid any part or portion of the occupational charges. The matter was mentioned before the Honorable Court on such and such. The Honorable pleased to pass giving direction for filing completion of hearing of the suit. A copy of the order dated with annexed here. However, due to non-compliance, conditional leave to defend by making payment of monthly, the order of eviction of the defendant stand confirmed operation.
The main argument of the defense or the main plank of defense is there are two tenancies. There are two tenancies, and these two tenancies have rents which are less than 10,000,
Yes.
and thereby falling in the West Bengal Premises Tenancy Act and not under the Transfer of Property Act.
And the Honorable single
In your plaint also, you have said that two separate rent receipts were being issued.
two separate, but Millard, single judge has dealt with it. I'll show Millard, the Honorable single judge's first order, where there's a concession. I'll show the concession. What was the concession?
What we are thinking is, what is the nature of defense? If this is the nature of defense, then whether the issue of applicability of Transfer of Property Act
Would apply or not?
would apply or not is a matter to be decided by the court.
Absolutely.
And it may be decided on the basis of the evidence that you need,
Absolutely. On my
subject
evidence.
to their cross-examination and arguments.
Absolutely.
So we can modify this portion of the order
Absolutely.
and fix a time. The suit may be disposed of expeditiously.
But this written statement, Millard, cannot be taken on record today.
Written statement, in our understanding, may not be taken.
Cannot be. Because, Millard, that is Supreme Court has made it clear. Written statement, subject, Millard, single judge, subject to, Millard, payment of that money.
Written statement, we
My case, Millard.
but the single judge's order also says as an additional ground for the plaintiff during trial. So you can always take out an application in the trial that you strike out the defects.
Millard, I came up. This is Millard in nature. Millard, he could have said so, but he said there is
What
no
he is saying
condition.
is, it is not a condition on the basis of which you get a decree automatically.
It's not a conditional leave to defend. That's he has said.
It's a
He could have said you don't get a decree automatically, but these are the consequences A, B, C, D, E, F, G, H,
decree subject to
A, B, C, D. He should have framed it, Millard. Well, I come to court with the high relief, Millard. Now, Millard, he should have framed it. What are the consequences? Now, Millard, kindly have a look at page 9, page 17, para 9. According to me, this is one tenancy. And I show Millard one portion of the single judge's order. The plaintiff together, para 9, the plaintiff together became and are entitled to joint and absolute owners of the tenanted premises, while the plaintiff number 1 wants undivided equivalent of such and such
where are
square
you
feet.
reading?
Millard,
Where are you?
17, para 9 of my plaint. Thus, the plaintiff together and are still the joint and absolute owner of the tenanted premises, while the plaintiff number 1 owns undivided share equivalent to 6,617 square feet, 70 square feet, and the plaintiff number 2 owns the balance share of 3055 square feet of the tenanted premises. And Millard, and he, Millard, accepts at page 31, and he says, he accepts and he says, kindly take his stand, Millard, at page 31, the letter of the defendant, 8th of August 2012. The area is, Millard, 1. It's not a demarcated area. He is occupying the total area in question. Kindly have a look at page 31, the letter of the defendant. We are in receipt of your letter dated 11th of July 2012 informing us as per the High Court order, the properties have been divided and your shares in the area is 305 square feet, 55 square feet. We are the
So
tenant.
there was a partition between.
No. There was a scheme of arrangement.
Scheme under the.
He was occupying Millard. His erstwhile Millard. His erstwhile in interest Millard. Person in interest was occupying the entirety. There was a scheme of arrangement by the High Court. It went in, Millard, to there were 4 companies. By way of this scheme of arrangement, Millard, this tenancy was allotted undivided share, Millard. This area was allotted or the space was allotted to, Millard, the 2 companies. So instead of 1 plaintiff, there are now, Millard, 2 plaintiffs. The space is single, but under the scheme of arrangement, Millard, it has been allotted to, Millard, plaintiff number 1, 6,000, plaintiff number 2, Millard, 3,000. Tenancy is 1. Proportionate share is different. So I'm receiving rent, Millard. 2 rent receipts, Millard, are given, Millard. That is, Millard, the case. I am giving 2 rent receipts. Lordship, and this is as per his request. This is his request. We'd request you to kindly raise rents received in proportion to enable us to give rent directly to you. We'd also request Mrs. Khaitan and Company to pass separate letters conferring about this scheme, wherein you become the absolute owner of the undivided property area of 3055, which is in your possession, our rent receipt along with the solution pay the rent. So this is the case. Is his request, below 2 rent receipts, he will pay rent separately to both the landlords. The tenancy remains the same. The area remains the same. And this is, my lord, if your lordship now test this, my lord. Kindly look at, my lord. Page 46. দেখাবে কি কি দেখাবে জাজমেন্ট কি কি দেখাবে আর হুম
His interpretation between all this process is zero. So
ওই আমি যেটা দেখো ওর প্যারাটা বার করে দাও সঞ্জয় প্যারা 21 লিখে রেখেছিস তো
Vijay,
হুম।
Vijay,
আমি কি দেখাবো বলে
single judge has subject of his defense in entirety. And that is what
কত টাকা ডিউ হয়েছে আজ অব্দি
operating works. He does not think it's positive.
Millard, the issue, as Lordship rightly asked me, page 44, if a Lordship takes Lordship's brief once, page 44, the order of the single judge.
We have gone through it. We have gone through it.
And Millard, there is
There
a
are two
concession.
issues which the
Concession, Millard.
concession recorded, conduct recorded.
Concession.
Concession that you will give a separate receipt has been recorded. Conduct of filing a suit under the Premises Tenancy Act also recorded. Taking into consideration too, Honorable Single Judge holds it's not a case of no defense, but it's a case of a feeble defense. So his lordship was of the view it won't be appropriate on the anvil of fairness and natural justice to completely shut out the defendant. However, he should be saddled with some conditions, namely of deposits. This goes up to the division bench, and the division bench says, no, there is a robust defense. Robust defense, unconditional, go for full trial. This goes to the Supreme Court, and the Supreme Court says that there have been debates on whether this is covered by Transfer of Property Act or West Bengal Tenancy Act. This will be decided in the suit. You deposit 4 lakhs. 20.
2 lakhs. 2 lakhs. 2 lakhs. 2 lakhs. 2 lakhs.
Yes.
SLP is 2 lakhs. 2 lakhs.
2 lakh tax
per month
as occupational charges
per month.
So and so.
On and from first.
Payments will abide by the final outcome of the suit. The question is, does it set aside the order of the division? The division bench's order
is unconditional. It in effect sets set aside. In effect. Because it's ultimately what? Division bench says, Millard, subject to correction, Lordship corrects me. It modifies the single judge's order. Division bench is unconditional leave. That's the ultimate direct, whatever he has said. Because it's an analysis or Millard decision-making process leading to what? Unconditional leave to defend.
Millard, these are not interpretation of statutes. It's the order of the court. The order of the court is simple. 2 lakhs as occupational charges and payment to abide by the final outcome.
The condition to defend the suit.
Final outcome of the suit.
It's a condition.
So it is not converting the suit from ordinary suit to a summary suit. It is not converting the suit from an ordinary suit to a summary suit. It is only putting a condition of occupational charges.
To defend this suit.
Where is that? Where is that?
That is, Millard, in the context of, Millard, the application
that
before
is
you.
That.
Look,
it just says occupational charges.
Millard, naturally, Millard, if Supreme Court decides the Chapter 13A application.
We would have understood if their lordship said that this order, the order for unconditional leave is modified.
Milord,
It just says, having heard and having perused, we are of
let
the
us,
view
Milord, read it
that
together.
ends of justice would be met if respondents are directed to pay 2 lakhs per month for use and occupation
Yes.
with effect from so and so. We order accordingly, payments would abide by the final outcome of the suit. The suit shall be disposed of expeditiously. It does not say that this will be treated as a conditional leave to defend,
Milord,
which conditional leave to defend was set aside by the division bench of this court. It says occupational charges are to be paid at this rate, or in other words, it will be not be the contract rate but the occupational charges rate.
this you have to pay.
Now, if you do that does not pay that, that and that is what the single judge held is an additional ground for eviction in the suit.
Milord, kindly, Milord, takes Milord page 68 with me. If you say 66, Milord, the Supreme Court, Milord, records in paragraph 3, that's his chapter 13, capital A, Milord. Milord, the conditional leave, Milord, what the Supreme Court is, Milord, in paragraph 3 itself, chapter 13. No difficulty. In a chapter 13A, Milord, any order, Milord, imposing, Milord, is, Milord, a conditional leave to defend. That's, Milord, because Supreme Court had nothing else.
If you felt that, you should have made an application for clarification with the Supreme Court that please convert it to a conditional leave. It just says occupational charges with effect from so and so.
But it's in context of chapter 13, a lordship will find at paragraph 3, Milord, of the order.
No, that nobody doubts.
দেখাচ্ছি।
Hmm.
If your lordship takes,
Hmm.
reads, Milord, para 3 with, Milord, page 68, Milord, or para 7, last portion. If it was, Milord, without context to anything, Milord, naturally, Milord. But if it's in context of chapter 13, then this could be the only logical conclusion, Milord. Otherwise, the order, Milord, becomes meaningless.
Hmm.
কোন paragraph?
Let us hear Mr.
Only one authority I just cite, Milord, and I take my seat, Milord. That's all, and one page. That's all. Milord, this is 2010, volume 5, Supreme Court cases, Milord. Milord, kindly have a look at paragraph 31. Well settled, Milord. It is well settled. SCC. page 388, para 31. It is well settled that an order of court must be construed having regard to the text 31, 31. It is well settled that an order of court must be construed having regard to the text and context in which the same has been passed. For the said purpose, judgment of the court is required to be read in its entirety. A judgment, it is well settled, cannot be read as a statute. Construction of a judgment should be made in light of the factual metrics involved therein. What is more important to see the issue involved therein and the context wherein the observations were made. Observation of the judgment, it should not be read in isolation or out of context. This is what that is, Millard. And Millard, just I sit down, Millard. Lord, I'm grateful for Lordship for such. Just one Millard page I show and I take my seat. Kindly have a look at. T6, if your Lordship's brief, Lordship takes one and I sit down.
Yes.
Kindly takes Millard 10 lines from the bottom. It is not disputed from the bar that joint owners can file a
I've already
composite.
marked that.
Great.
But I have also marked 47.
Yes.
First two lines.
Yes. West Bengal. So here, that was on concession.
Concession, conduct. See, the tenancy even before amalgamation was of two companies. Udyog Industries. Podak Udyog, Podar Industries. It was not a single landlord, joint landlord. Undisputed in respect of two landlords, in respect of a tenancy, a single suit can be filed for eviction and it will be treated as a composite tenancy. Now, whether in the facts of the case it was a composite tenancy or not is to be determined. And we are of the view this issue needs to be decided by the judge on the basis of the plaintiff's case. On the basis of the plaintiff's case, subject to cross-examination of the plaintiff's case by the defendant. The defendant's right to take out a defense, as you argue, subject to hearing Mr. Bose, stands forfeited because of his conduct. This is sum and substance.
Okay. Only one thing, for what I said, Millard, the view is that irrespective what market rate has to be paid, Millard, the Lordship considers nothing to do with this judgment. This is completely contrary, Millard. Judge Saib, paragraph Lordship takes 21 of this judgment. You file a suit, you apply for market rent, and the obligation of the defendant is to pay. It went from this court, Millard, para 21 of the judgment, Lordship considers. These are my respectful submissions.
But then this is not really relevant for our
purpose. Not for
our case, Mr. Bose.
Grateful. Grateful. Great.
Well, if your Lordship kindly takes the division bench order once.
Yes.
Well, what was in appeal before the division bench was whether the order passed by the single judge granting conditional leave to defend, well, whether such condition could be imposed in the facts on the application, because when chapter 13 application
right. Whether leave to defend was there, it is not a case where it was said to be completely unmerited and thrown out. But on conditions, leave to defend under Rule 9 was given.
Right.
There was another requirement that if there is a failure, automatic decree without application.
Without application.
These two parts. Division bench, we are just subject. Division bench alters this, says no, merit is there. So don't put this harsh condition of
Correct.
4 lakhs occupational charge
Right.
and thereby burden.
Right.
Let them defend.
Right.
Correct. Against that, they go up in appeal.
My lord.
And the Supreme Court makes a via media.
My lord. It does.
There is not 4 lakhs, 2 lakhs occupational charge from 2006. And we order accordingly, suit will be decided. Because Supreme Court cannot foresee that your client is going to default. However, neither the Supreme Court does not reiterate the issue of an automatic decree without applying under Rule 10. Now, when Rule 10 is applied, further orders are to be filed. And Mr. Ghosh also, by his application, comes to this that Rule 10 is to be invoked here. That was in terms an application under Rule 10. Draw up a decree. If it was not, then Mr. Ghosh, correct us if I am wrong. I am absolutely not. I feel, embarrassed to make any comment on the original side rules before two stalwarts. If our understanding, if Justice Sen's order survived till the Supreme Court, Mr. Ghosh did not have made an application, he would have filed an execution petition. Correct. It would have been an execution petition. You file an execution petition, please execute the summary decree. This is the summary decree, please. But what is the prayer?
Right.
So Rule 10 was invoked. It's not the appellant's case that in entirety single judge's order was upheld. What the appellant would like us to persuade in face of the order of the honorable single judge now is 2 things. A, whether to hold that this was come to page 98, whether is not a conditional leave to defend the suit. This is where he is joining issue. It is a conditional leave to defend the suit.
Yes.
Because we have to see the direction in the perspective of the order under challenge and the nature of the proceeding before the Supreme Court. Nature of the proceeding was a summary suit.
My lord.
There was a conditional leave that became unconditional leave. And then that again, a condition is being imposed by the Supreme Court. So to say that the leave to defend is an unconditional suit is something which we would love to clarify subject to hearing you. Second portion of the order, that what happens if, and that's the honorable single judge's reasoning, or rather the logic, that I hold that it is not a condition for leave. Then what happens if Mr. Moinak Bose's client defaults? He says it's an additional ground for the plaintiff during the suit. We would like to take a cue from that. What is the additional relief the plaintiff would seek? In our understanding, it would be striking of your defense. But that would not give them an automatic decree until and unless the pleadings are sufficient to prove the cause of action in light of the law applicable to the facts of the case. Because Mr. Basu, in this case again, it's not a question really of evaluation of facts. It's a question of determining 2 things. One, whether there were 2 tenancies and
Absolutely.
how much Section 106 will apply. In this, if your client had not defaulted, naturally, you would have been entitled to lead evidence that there was a partition between the 2 tenancies but in the facts of this case, we are loath to put that burden on the plaintiff in light of your conduct. But we will not take away the onus of the plaintiff to prove that the facts of the case fall within the ambit of Section 106 of the Evidence Act. This is our understanding. Now you make your submissions.
If your lordship, if I may just, my lord, just revise the entire facts. My lord, when the learned single judge passed the order giving conditional leave, well, there was a consequences provided in the conditional leave. That I am giving you leave under chapter 13A, which is like a summary suit order 37. But my lord, there's a distinction between chapter 13A and a summary suit under order 37 of the Code of Civil Procedure. My lord, chapter 13A contemplates a situation where the court has a discretion to impose conditions as a ground to defend. So if a condition is imposed, my understanding of my lord rule 9 is, if a condition is imposed by the judge that if you do X, whether it is by way of a security or otherwise, you give a right to defend. Failing which you don't have a right to defend. That doesn't mean plaintiff automatically gets a decree.
This is also, we agree with you.
Right. Now, my lord, so the order of the single
But if you
judge,
see why Justice Sen said that is, please read again with us. We may be incorrect in our reading. 9. Rule 9, please leave to defend, read it.
my lord. My lord, leave to defend may be given unconditionally
Forget it.
or
Subject
to such terms as to giving security, comma, or time, comma, or mode or trial.
not mode or trial. Mode of trial.
My book says or, my lord.
What is you're typing? We had a lawyer. We had a lawyer in Alipur court practicing criminal. He had a code of criminal procedure
But
where
this also says
a
or.
non-bailable offense.
This also says or, surprisingly. Two books says or.
2 books say off. And it cannot be mode or trial, it will be mode of trial. A syntax,
I think we
it cannot be or.
I think we are getting the same book.
That's a typographical error. Mode of trial. Because
Must
it
be a-
cannot be mode or trial.
No, correct.
Mode of trial.
So our books.
And why I insist on this word is I was trying to see the source of power of Justice Sen's order
My lord.
of saying that the default will have an automatic decree without applying under Rule 10.
Correct.
In our understanding is his lordship had imposed not only a condition but also provided for the mode of trial, namely an automatic decree. Either you pay, alternatively an automatic decree, no application under Rule 10. Today you are saved, Mr. Bose,
My lord.
because Mr. Ghosh also, by
Has applied.
his conduct, accepts that the Supreme Court order does not uphold the mode of trial indicated by Justice Sen's order. So we are left with the very small area of
My lord.
clarification that it is a conditional leave to defend, and the consequence of that conditional leave is your written statement cannot be considered. The plaintiff has to prove its case on the basis of the plaint and evidence led, subject to cross-examination of the plaintiff's case. This is our understanding. Can we pass that order?
My lord, if I may just come back to mode of trial once. My lord, several apart from the type of conditions that the judge can impose under Rule 9, if your lordship will see, terms as to giving security, time, or mode of trial.
Automatic decree.
Lord, mode of trial, would mode of trial give the authority to the judge
Yes.
to pass a decree,
Yes.
to give a decree?
Because what is a decree?
My lord.
It's a part of the last step of trial.
Correct.
Judgment
It's a final outcome of an
and
adjudication
so he
process.
says mode of trial means automatic decree, no trial, no application for further directions
Hmm.
as to the further conduct of the suit. See, please see,
My lord.
see the word mode of trial in relation to further conduct of suit. So leave to defend is not an automatic decree always. Leave to defend, failure, consequences is rule 10.
Correct.
And that consequence is what we are to decide now. In this situation, the Honorable Single Judge, whose order is under appeal, says the order of the Supreme Court is not a leave to defend at all. It is a direction for deposit whose default is to be considered as a consequence in the trial. These two parts are contradictory.
It is.
First, it was a direction for deposit in context to leave to defend and therefore would be contextually read. One, as Mr. Ghosh said. Secondly, what would be the contextual inference? We don't agree with Mr. Ghosh. And he also accepts that we have asked for the sky. But it's not the sky that we expect.
Right.
What we expect is that at least his defense should be struck off. He's not paid the occupational charges, where we find some merit.
Right.
Otherwise, it becomes absolutely an act in futility. Occupation charges directed to be paid, not paid, then full-fledged trial. Why? That will defeat the ends of justice for which it was imposed in the first place. All right, Mr. Bose, we clarify the order. We are not setting aside the order. We just clarify how the consequences are to be.
My lord, just two things, my lord.
Ah.
My lord, what fell from your lordship is that Rule 10 gives the authority to the judge to give directions for further conduct of the suit. So this direction could have been a direction to proceed with the suit by striking out the defense.
Absolutely.
Now, my lord, if your lordship comes back to the Supreme Court order, now, my lord, then, my lord, the learned judge would be required to clarify the Supreme Court order. If your lordship will really see the Supreme Court order, my lord, kindly once take para 6, I'll trouble your lordship with only one paragraph. Kindly take page 67, running page 67, paragraph 6. It says, a number of issues and contentions have been raised by the appellants and the respondents before us, which we propose not to discuss and decide as a civil suit is still pending and has not been decided. It is pointed out to us that the respondents were paying such and such to the first appellant and such to the second appellant, aggregating to such and such as for rent / occupational charges. The present appeals were adjourned vide order of such and such at the joint request made by the learned counsel appearing for the parties to enable them to get some more instructions from their respective clients as to the current market rate. By order of such and such, learned counsel for the respondent has prayed for and was granted 3 weeks' time to file valuation report, which has been done. Having heard the learned counsel for the parties and having perused the records, we are of the view that ends of justice would be met if the respondents are directed to pay 2 lakh rupees per month as use and occupational charges for the premises with effect from 1st March 2017.
We order accordingly.
We order accordingly. Then the payments made would abide by the final outcome of the suit. Thereafter, it says the learned single judge before whom the civil suit is still pending is requested to dispose of the civil suit expeditiously. Appeal disposed of. So there are two things. The division bench order is not interfered with. So the unconditional leave remains.
It's modified.
Well,
Division bench order is modified. It is modified, not interfered with is wrong. It is modified.
My lord, the imposition of
Yes.
the
That
payment
is
as
the
occupational
condition which
charges.
is being imposed
Yes, my lord.
by the Supreme
My
Court,
lord.
and the Supreme Court condition is imposed
My lord.
in context of two directions.
My lord.
One direction is a conditional leave
And the
and
other is unconditional.
unconditional. It says no, not conditional at the rate of 4 lakhs, but at the rate of 2 lakhs.
My lord, my understanding will be subject to correction. My lord, unconditional leave to defend the suit remains.
Okay. Okay.
But Supreme Court imposes a third condition that you pay occupational charges subject to the result of the suit. My lord, admitted position, I haven't paid that.
Right.
So now, my lord, what the plaintiff is trying to interpret is the unconditional leave which was given by the division bench when it went up in appeal before the Supreme Court, there was a modification of that unconditional leave to a conditional leave. So this in my
Reading
respectful
is not.
submission and interpretation of the order of the Supreme Court, this is not a condition to defend. Admittedly, it's a direction to pay occupational charges because you are enjoying the property. During the pendency of the, there's a departure in the, recently there's a departure of the Supreme Court. Supreme Court is saying during the pendency of the suit, defendant can be directed to pay subject to the result of the suit, whether it is a regular suit or a Chapter 13A suit. That 2024 is that. This, if your lordship will see towards the end of this 2024 judgment, in an interlocutory application, which went up from this court after a second appeal, in an interlocutory application, Supreme Court say as an ad hoc payment, you pay so much by way of occupational charges. So that cannot be construed to be a payment for condition to defend. I must have unconditional right to defend. If I don't pay 2 lakh rupees or the amount which has been directed to be paid, by the consequence, it could be possibly they can execute it by way of a money decree or whatever. So because it's a direction to pay, or maybe I'm in contempt, they can go and file a contempt before the Supreme Court that there was a direction to do something, they did not do it. But what my respectful submission is that that direction cannot be construed to be a condition to defend the suit. The suit has been already held that I have a right, because the moment I show some defense, Chapter 13 say any defense, suit goes to it becomes a regular suit. It protects the character of a regular suit, ceases to be a summary suit, because summary suit is limited.
True.
So, my limited understanding is that the Supreme Court order that the direction to pay is not a condition to defend. If I haven't paid, the consequences will follow. They have to take steps in accordance with law. But this cannot be read as a condition.
All right.
But these are my respectful submissions.
Great.
One just I should have pointed on. If your lordship, my lord, kindly takes the next page, the last order of the Supreme Court is at page 68. It ends at 68. Kindly take 69.
Hmm.
They accepted the Supreme Court order and subsequently approached the single judge for trial of the, and thereafter, my lord, much has proceeded and issues have also been framed by the suit court. My lord, in July 2024, parties have filed their respective issues and issues have been framed. So, my lord, suit is at effectively at the trial stage now. And my lord, whether this would be a suit under the Transfer of Property Act or whether I'm a protected tenant under the premises tenure, this is also one of the issues that has been framed.
When this application was taken out?
This application was taken out. This is an afterthought, complete afterthought. This application was taken out much later.
Much later one?
It's in December 2019.
December 2019. Issue copy frame.
November 19, they had approached the court pursuant to the Supreme Court order.
And the Supreme Court order
This GA was taken out in
December 2019.
December 2019.
December 29.
2019.
That your lordship will find.
That's Willard, part Willard of the petition. That's Willard, December 29.
page.
Page
Well, the
number 11.
affirmation page-
11, Lordship takes page number 11. 12th of December 2019.
December 20.
Mhm. And my lord, the directions which is recorded in page 69, the order of 19th November, they have all been complied with. A judge's brief of documents, discovery inspection, issues have been framed.
So according to you, the suit has proceeded as a
Yes, my lord. As a regular suit.
regular suit.
Regular suit. And in fact, they were required to produce their witness when they took the adjournment. The witness did not come to
This
the court.
matter I had filed it because consequence Willard, 2 years Willard not paid anything as per the court order. Now Willard, I filed it
Right,
Willard.
but then when in 2019, the order of the Supreme Court was passed
In October, my lord.
in
18th October.
18th October.
Okay. Thereafter, they did not
No.
proceed.
They did not. They should have paid Millard. It's a condition of the
I will
Supreme Court.
proceed.
One has to comply. They should have paid.
So they paid and
They did not pay.
I did not pay.
They did not pay. It's
so
an
this-
admitted position.
This stance was on the understanding that they would be paying the.
Yes, they would be paying. Millard, anyway, Supreme Court order if someone has to comply with.
So, all right, take down.
Grateful. Millard.
Appellants are the plaintiffs. Now, appellants are the landlords of 9725 square feet in the ground floor of premises number 118 Rabindra Saran, Kolkata 1, hereinafter referred to as the demised premises. The respondent is the respondent appellant plaintiffs. Respondent defendant was a monthly tenant at a monthly rent of 12,278 per month. 78. On 23rd April no, On or about 19th August 1997, initially the tenancy initially the defendant uh, respondent defendant was a tenant under Messrs. Poddar under appellant number one, first appellant, and one Messrs. Poddar projects. Pursuant to a scheme of arrangement sanctioned by this court, did a order dated 7th April 1998. Undivided share of the tenancy an undivided share of the tenancy comprising of 3055 square feet was transferred in favor of the appellant number in favor of the second appellant, thereby the two appellants thereby the appellants became the joint landlords of the tenancy in question, of the tenants of the tenants. On the request of the now though the tenancy was a single premises, on the request of the respondent defendant, separate rent receipts were issued to the respective landlords On 3rd of October 2012, the landlords served a notice upon the respondent defendant terminating the monthly tenancy and calling upon the defendant to quit, vacate and hand over the peaceful possession of the tenancy under section 106 of the Transfer of Property Act. The notice was duly received by the respondent, but the latter did not vacate the tenants. On 23rd April 2013, a suit was filed before this honorable court, inter alia, praying for a decree of eviction of the respondent from the tenanted premises and for mean profits. In the said suit, an application under Chapter 13A of the original site rules, being GA 2883 of 2013, was filed for summary decree of eviction. By judgment and order, a honorable single judge, after hearing the parties, a honorable single judge inter alia held that the defense of the respondent defendant was feeble and was feeble, but there, inverted comma, could be is by page 47. Holding as aforesaid, the honorable single judge permitted leave to the respondent, granted conditional leave to the respondent as follows. Page 50, setup. Respondent defendant carried the matter in appeal, and the honorable division bench modified the order of the honorable single judge and granted conditional leave in favor of the appellant, in favor of the respondent defendant.
Unconditional.
Unconditional leave in favor of the respondent defendant to defend the suit. Appellants challenged the order before the Honorable Apex Court. Honorable Apex Court after hearing the parties, disposed of the special leave petition in the following terms. Paragraph 7 and 8, page 67-68. Admittedly, the respondent defendants have failed and neglected, have not paid occupational charges at the rate of rupees 2 lakhs per month in terms of the order of the Honorable Apex Court. In this backdrop, appellants took out an application, took out GA 6 of 2019, inter alia praying for drawing up of decree of eviction and an inquiry and inter alia drawing up a decree for eviction. Full stop. Honorable single judge by the impugned judgment and order held that the direction passed by the Honorable Supreme Apex Court is not a conditional leave to defend the suit. Failure and the failure of the respondent to deposit the occupational charges as directed may be taken as an additional ground during trial of the suit. Full stop. The plaintiffs have claimed, now plaintiffs had taken out an application under Chapter 13A of the High Court, or under Chapter 13A of the rules of the original side rules of the High Court, which inter alia provides rules of the High Court seeking Chapter 13A for a summary decree. Full stop. For a summary decree. Rule 6 of Rule 6 to Rule 10 of the Rule 6 to Rule 10 of Chapter 13A, inter alia provides for the manner in which the judge may deal with a prayer for summary decree under the said chapter. Rule 6 states if the defendant makes out a good defense, the Rule 6 না তার আগে Rule 6 to 10 decree under the said chapter provides the procedure in which the judge shall deal with a prayer for summary decree in the event the defendant enters appearance and opposes such prayer. In the event the judge is of the view, in the event the judge is satisfied that there is a good defense, he shall refuse the now, in the event the judge is of the view that the defense of the appellant is is a sham. In the event the judge is of the view that the defendant has no defense, or the defense is illusory or sham, or is a he shall refuse the prayer of the defendant to for leave to defend, and forthwith pronounce judgment in favor of the plaintiff. In the event, in the alternative, if the judge is of the view that the defendant has made out a good defense, the defendant shall be granted unconditional leave to defend. Shall be in the event the judge is of the view uh, has made out a good defense or has raised a triable issue, he shall be granted unconditional leave to defend. When the case of the defendant is weak, when the case of the defendant is weak, but now even when the case of the defendant is practically moonshine, the court may allow the defendant to defend the suit if he secures now if the court may allow the defendant to defend the suit on such terms and conditions as the court may deem fit and proper. Honorable single judge, while dealing with the honorable single judge dealt with the defense of the appellant, defense of the respondent defendant is respondent defendant admits the tenancy as well as the receipt of notice to quit under under section 106 of the Transfer of Property Act. It is his defense, the sole defense raised by him is that there are two tenancies. There are two tenancies and not a composite one. Honorable single judge referred to the manner of creation of tenancy, referred to the nature of the tenancy, which is a single go down, and referred to the nature of tenancy, which is a single go down, manner of its creation, and the concession and the circumstances in which to rent and the circumstances in which the and the circumstances in which separate rent receipts were issued to the joint landlords to come to the conclusion that the tenancy is a composite one, and the defense of the appellant, respondent, was extremely feeble. Notwithstanding such observation, notwithstanding such finding, the judge, the honorable judge, was of the view that principles of natural justice, was of the view that the flickering hope at the end of the tunnel was of the view that the last hope of the tenant ought not to be extinguished, and extended the concession of leave to defend on terms and conditions on payment of occupational charges at the rate of 4 lakhs per month on and from 17th on and from March 2017 till disposal of suit. In appeal, the honorable division bench was of the view that in appeal, the honorable division bench referred to Messrs. W. Newman Company Limited versus Apollo's Zipper India Limited, referring to so and so, held that the validity of the held that the defense was not an illusory or moonshine. The defense was not illusory and moonshine, and granted unconditional leave to defend. Honorable Supreme Court while directing Honorable Supreme Court Honorable Supreme Court modified the order, and Honorable Supreme Court in appeal, Honorable Supreme Court in its Honorable Supreme Court uh, modified the order, the aforesaid order, and directed that in ends of justice, the respondent tenant shall pay rupees 2 lakhs per month as use and occupational charges with effect from 1/3/2017. The payments shall abide by the final outcome of the suit. Full stop. Mr. Ghosh, in terms of the as the respondent failed to make the payments, failed to pay the occupational charges, appellants have taken out took out an application for a summary decree. Full stop. Mr. Ghosh contends conditional leave. Mr. Ghosh contends as terms of conditional leave to appeal had not been complied with. A decree for eviction ought to be automatically passed. On the other hand, per contra, Mr. Bose would argue the order passed by the division bench granting unconditional leave had not been disturbed. Honorable Apex Court merely added an additional requirement, namely deposit of occupational charges at rate of rupees 2 lakhs per month. Full stop. Non-compliance of this direction cannot amount to an automatic decree for eviction. Full stop. The submissions at the bar, the issue raised before us calls for application of calls for interpretation of the directions of the Apex Court, in its order dated 18th October 2019. By the said order, the Apex Court had called upon the respondent tenants to deposit a sum of rupees 2 lakhs per month as occupational charges for the premises with effect from 1/3/2017. It was further directed that payments shall abide by the final outcome of the suit. Full stop. Directions were also given for expeditious disposal of the suit. If these directions are read in isolation, ordinarily, if the directions are read in isolation, it would not, it may not lead to the irresistible inference that the default in payment of the occupational charges would amount to a forfeiture of leave to defend. However, as rightly argued by Mr. Ghosh, directions argued by Mr. Ghosh, directions in an order cannot be read out of context. Cannot be read out of context. They must be out of context. The said direction had been passed in an appeal from an order permitting unconditional leave to appeal. Honorable single judge had কি বললাম it was না তার আগের লাইনটা it cannot be read in context, out of context. It must be appreciated in the backdrop of the facts and circumstances of the case, particularly the nature of proceedings from which the appeal before the Honorable Apex Court had originated, had arisen, full stop. Appellants had taken out an application under Chapter 13A for summary decree. Honorable single judge granted conditional leave to, holding that the tenant's case is a feeble one, granted conditional leave to appeal, conditional leave to defend. Honorable division bench of this court modified the order and permitted unconditional leave to defend. This order was challenged before the Supreme Court, Honorable Supreme Court. In this Honorable Supreme Court, and the court directed the defendant to deposit 2 lakhs per month instead of 4 lakhs per month, as directed in the conditional order of the Honorable Single Judge as occupational charges. As occupational charges. Read contextually, read context from this perspective, the direction to deposit 2 lakhs per month for occupational charges cannot be in this perspective the direction for occupational charges for deposit of 2 lakhs per month as occupational charges cannot be considered as an unilateral direction, but must be contextually understood to be a condition for the respondent defendant understood as a condition for leave to defend. As a condition for leave to defend. If construed otherwise, the consequences of if construed otherwise, the order would be rendered nugatory, as no substantial consequence of non-payment would inure কি বললাম
If construed otherwise, the order has no substantial consequence.
as no substantial punitive consequences of non-payment would arise upon the respondent defendant. The observation, the Honorable Single Judge failed to appreciate the direction of the Honorable Supreme Court in its right perspective and incorrectly held that the direction was not a conditional leave to defend the suit. Defend the suit. Full stop. Defend the suit. Full stop. Accordingly, we set aside the order of the Honorable Single Judge and direct that the consequence of the suit, it has also been argued that the appellants have blown hot and cold at the same time, referring to order dated 19th November 2019. Mr. Bose contends that the appellants had acceded to the suit being tried out as an ordinary suit and thereafter changed course and sought to invoke the summary proceedings afresh. Summary proceedings again. We find little substance in this submission too. Honorable Supreme Court, Apex Court gulo sob Supreme Court kореche. Honorable Supreme Court had given conditional leave to defend the suit vide order dated 18th October 2019. As per the condition, now Honorable Supreme Court had imposed the condition to pay rupees 2 lakhs per month as occupational charges with effect from 1st March 2017 on October 18th, 2019. It was not in the contemplation of the appellants barely a month thereafter when the suit came up for hearing. It was not in the farthest contemplation of the appellants that the respondent defendant would not comply with the aforesaid condition. Accordingly, they agreed to the suit being tried as a contested one. Unfortunately, the hopes were belied and the appellant took out application for seeking a decree, took out an application for summary decree in for drawing up for drawing up of decree due to non-compliance, due to breach of the conditions in the Supreme Court's order, Supreme Court's order. In light of the aforesaid discussion, we are of the view the breach of the order, breach of the condition. We are of the view the breach of the condition imposed by the Supreme Court, by the Honorable Supreme Court, in order dated, we are of the considered view the condition imposed by the order passed by the Honorable Supreme Court requiring the appellant to deposit occupational charges at the rate of 2 lakhs per month with effect from 1/3/2017 was a condition to grant leave to defend in the suit. Failure to go in the event of such failure, the appellants were entitled to take out an application under Rule 10 for seeking directions as to further conduct of the suit. We don't, though we are not in agreement with, we do not agree with Mr. Ghosh that the we don't কি বললাম না কি বললাম further conduct of the
for seeking directions
Rule 10 for seeking further direction further conduct of the suit. In the factual further conduct of the suit, though we do not agree with Mr. Ghosh, further conduct of the suit, in this accordingly, further conduct of the suit, Mr. Ghosh's client further conduct of the suit, as the defendant has now we in the aforesaid factual matrix, we are of the view respondent defendants have forfeited their right to defend the suit by failing to comply with the directions, by failing to deposit 2 lakhs per month as occupational charges with effect from 1/3/2017. Stop. Accordingly, we direct that the suit be heard. Accordingly, we direct that the defense of the respondent defendant in the suit be struck off and the suit be heard in the following manner, and the suit be heard accordingly. We did not further set out.
Not necessary.
My right to
Cross-examine.
Cross-examine. That is always there.
Needless to mention,
It
the
is always there.
respondent defendant shall have a right to cross-examine the witnesses, the plaintiff's witnesses on his case, but would not be entitled to make out on the plaintiff's case only.
Grateful.
Full stop.
Grateful. Grateful for your patience, hearing Lordship.
The order passed by the single judge is accordingly, we have set aside.
Lordship has already set aside. Grateful. Grateful for your patience.
Hello, there was an issue framed in the suit whether the tenancy is governed by the Premises Tenancy Act or not. It has already been framed. So,
He has to prove that.
I have to
Yes,
prove
yes.
that.
issues are independent of your defense in the written statement.
Arises out of the defense that I take and the plaintiff's case that makes it an issue.
Huh.
Since this is a legal issue,
He can
It
always
has to be
argue. He can
Mr.
always argue.
what we said. Let us say question of limitation.
That is to be decided.
Until and unless limitation on the basis of mixed question of fact cannot be decided. But on admitted fact, Order 7 Rule 11 limitation may be applied.
Absolutely.
So you are entitled to that.
Absolutely. Again, Miller, again change Order 7, Rule 11 limitation. Now, Miller, pure question. Previously can't be.
No, now too can be.
Now can be. Now can be.
The judgment. It
Yes,
can
now can be.
even adverse possession
Can
yes,
can be.
and it can be
Position is-
taken as a
as a preliminary point.
Preliminary point. Can be.
previously it could be used only as a shield.
So
Now it
that
can be used
too-
as a sword.
That
also.
is gone.
Now shield showed
Now before trial.
before trial as Order
trial
14.
adverse possession.
Absolutely.
Isn't it? So it is always in flux.
Correct, of course.
Always
in flux.
great.
Thank you for,
Grateful, Miller.
for your patience.
For my lord's patience for hearing
We,
us.
we tend to dispose of matters here.
Absolutely.
That
Absolutely.
they don't keep pending and headaches are caused.
No baggage back.
No baggage.
Grateful. Much.
Carry no prisoner. Thank you.
जो CPC था দিয়ে দিয়েছে স্থানে আছে একটা
সিপিসি ওখানে আছে দেখো আর
Next matter.
CPC টা ওই
ওই সরি
থ্যাংক ইউ গ্রেট
एकदम से। Has to be ready. Otherwise, it becomes needed. What is the consequence? There's no consequence. Next.
ওয়ান করে দিলাম
What? Apple side. Next.
Lordship, this is the last order of directorate or report. This is the report.
What has he done?
Lordship, the IO got transferred, Your Lordship. Now the present IO is there. The warrant has been issued, Your Lordship, against the petitioner. And
Yes.
the main principal accused, Your Lordship, he got surrendered and he's in custody.
Yes, but what about this man?
This man, he got transferred in, he's in another PS and he don't have anything to say, Your Lordship. They have called him, but
No,
he's,
our question is why
that's the thing, Your Lordship.
he has not been arrested.
Lordship.
Someone must take over investigation. Madam, investigation doesn't end with a submission of charge sheet against an absconding accused. Execution of processes is a continuation of that
That's true,
investigation.
Your Lordship.
So who is doing that?
Now the present IO is he.
Yes, so why present IO has not prayed for proclamation attachment?
Warrant has been issued. Your
Why?
Lordship.
So
Now,
warrant, he has not been able to execute the warrant. What prayer? Charge sheet was filed.
Lordship.
Charge sheet was filed. Then
The
what
charge sheet not
prayer?
submitted, Your Lordship.
Huh?
Investigation is pending,
Investigation is pending.
Lordship.
Then we will not allow these sort of things. He has to find it out. We are not satisfied with the steps taken for apprehension of the absconding accused. Laxity on part of police gives opportunity to these accused to repeatedly file applications for pre-arrest bail. We direct the So, Superintendent of Police,
No, commissioner. Howrah.
Howrah Commissionerate, Commissioner of Police, Howrah Commissioner, Police Commissionerate, to take necessary steps for to ensure that the uh, to ensure that the absconding accused is apprehended. Further report be filed on the adjourned date, 4 weeks. Next.
May I please, Your Lordship, my application. My lord, has heard this matter in length, my lord.
But we have forgotten.
What happened here, my lord? At the day of election, my lord, of the Panchayat Pradhan, my lord, an unwanted incident took place, my lord. All the confidential paper and ballots has been snatched by the hooligans, which was, my lord, affirmed by the or admitted by the block development officer in his affidavit and on report. My lord, kindly come to page 88 of my application first, my lord. 88. My lord, thereafter, my lord, I am coming with the orders. Orders show everything, my lord. My lord, 88 is the, my lord, initial my complaint which was made before the, my lord, the police station regarding, my lord, the hooliganism which took place during the course of, my lord, the election of a pradhan of the particular panchayat. Then, my lord, kindly come to, we have preferred and writ application before this honorable court, my lord, on order dated, my lord, page 92. Page 92. Page 92. Starting from the order, the 93 is the relevant portion, my lord. Learned counsel appearing for the on behalf of the state relies on the report which is taken on the record and submit as follows. There was a violation and took place and the presiding officer was brutally assaulted. Camera and phones were damaged. However, at the end of the day, there was a candidate belonging to such and such political party who was elected as a Gram Panchayat Pradhan. Case have already been started. In the meantime, next, my lord, after two paragraph, my lord, in the meantime, the state shall preserve all the available instrument relating to the meeting book and others, my lord. That was my direction to preserve all those documents. Next, my lord, 94. Page 94 is the order, my lord. Page 94 says, my lord, the block development officer, who is, my lord, the presiding officer there, my lord, under, my lord, his guardianship, my lord, everything has been done, my lord. Filed a report before this court, wherein from its appear the party winning the majority seat proposed the candidate to be elected as a pradhan, and the members of the minority political party proposed to another name. After obtaining the vote in ballot paper, the name of the pradhan was declared. Surprisingly, the name suggested by the winning party having majority member was not elected as a pradhan. Then, my lord, the skipping one paragraph, the block development officer such and such is directed to produce the original ballot paper relating to the election of the Pradhan, which was held on 10th August 2023. Then, my lord, the next order is, my lord, page 96. Page 96 says, my lord, the learned advocate appearing for the block development officer submit upon instruction that the original ballot papers cannot be produced before this court because the same were torn and snatched away by after election over. Then, my lord, reliance has been placed upon the complaint lodged by the returning officer such as such, which, my lord, also admitted by the police officer filing by their affidavit that there was a violation, case was registered. It appears from the complaint, the skipping, my lord, that paragraph, that the said complaint that after the election was held, the meeting was over such and such. Thereafter, a gang of hooligans entered into the meeting room and forcibly snatched away the confidential file containing the resolution. And I'm putting this question to myself, my lord. If there is no resolution, my lord, because, my lord, the prescribed authority was, my lord, in a scene over this matter, my lord, who will be, my lord, satisfied with the resolution? My lord, there was no resolution, and also there was a violation of rule, my lord. I will furnish before your lordship on last occasion. I will today I have handed over the same. The ballot and other relevant paper and thrown from into the pieces. The returning officer was physically assaulted and threatened with the sharp weapons. The mobile phone video camera used in recording of the meeting and presiding was destroyed. The block development officer had sent a team to rescue the returning officer. A complaint was lodged in the officer in charge of such and such, such and such. Then, my lord, thereafter, my lord, the order which was passed here. My lord, I am relying with the rule, my lord. This rule says, my lord, at least, my lord, 6 months, my lord, they have to preserve all the document. All the document relates to the election, my lord. If, my lord, the papers, the ballot papers, resolution books, and other document, if that has been destroyed at the day of election, my lord, how, my lord, he come to a conclusion that, my lord, that this person has been elected and this person has been elected on video, because video is in on basis of the report, my lord, video has to, my lord, act, my lord. This is the situation, my lord. And state, last occasion, state also filed their affidavit, and the police also filed affidavit. All affidavits admits in these facts, my lord. Uh, the rule which I relied on last occasion, that is, my lord, West Bengal Panchayat Constitution Rule 1957. 57.
Mr. Chatterjee, we are keeping it next Friday.
Very well.
Hmm.
Very well.
Bring 2 books. Here the Panchayat books are not.
Very.
And the constitution also. And the constitution also, my lord. Constitution, my lord, there is a clear bar, my lord, for filing this application before the Honorable High Court.
Is that
And
so?
the latest Supreme Court decision is also here, my lord.
Is that so?
Lordship,
That's so?
I shall satisfy Lordship on that.
Is that so? This is an election of a Pradhan,
Lordship,
not the election of a Panchayat member.
Lordship.
So,
But my lord, the election of Pradhan, I shall satisfy Lordship, my lord.
election of Pradhan is not subject matter of a suit.
Absolutely. But my lord, I shall satisfy Lordship, my
So,
lord.
where is the alternative remedy, sir, under the statute?
Election petition is there.
Why election petition? Election petition is respect of a Panchayat member, not in respect of the Pradhan.
Even my election of Pradhan also, my lord.
Show us that.
Yes, sir. On this date, I shall show you, Lordship.
Show us that. And was that point taken before the Honorable Single Judge?
No.
In appeal, you are taking the point of
They
alternative.
have taken, my lord, we have, my lord, on reply of this application, my lord, we have dealt with them.
Under the suit to be filed is with regard to election of the members of the Panchayat,
Lordship.
isn't it?
But my
What
Yes,
is
madam.
the suit under the statute? Power to institute suit election petition is against what?
against when the election process
Let us
in
see
respect
that,
of
that clause. Election petition.
Election petition 35.
Okay.
Election petition 35. No. That is, my lord, in people representative act, my lord. This is the rules, my lord.
What people's representative? It's not people's representative.
Constitutional rules.
Under the Panchayat Act.
What? Section 19, my lord. Just a minute. I'm sorry. At 79, perhaps my lord, section 79 of the West Bengal, subject to lordship kind sanction, 2003, my lord, West Bengal Panchayat Election Act. Election Act, my lord.
Election Act.
Panchayat Election Act.
Okay, later.
79.
Section
79, my lord. আপনারটা দিন না, স্যার, বুঝে গেছি। Malad, may I hand over, Malad? This is din.
এই ইলেকশনে it is does the election of a gram pradhan take place under the Panchayat Election Act
No,
or it takes place under the Panchayat Act?
Panchayat, Malad.
তাহলে
Then, Malad, this is my alternative argument. My lord was pleased to see this section, Malad. That's why I handed over. And
under this act, yes, this act is for the election of members,
individual, Malad.
not the election of pradhan or upapradhan under the parent act. So the suit, Mr. A. Mosharraf, we would like you to clarify this.
Lordship.
West Bengal Panchayat Election Act, and there you definitely have an argument, has an alternate remedy in the form of an election petition. And if that is not availed, then institution of a writ proceeding has generally been deprecated. Very exceptional situation you may.
Lordship.
The issue here is not election under the West Bengal Election Act, but election under the Panchayat Act of the office bearers of the Panchayat. And Section 79 of Election Act does not govern those elections. And therefore, it cannot be said that there is no statutory remedy. Definitely there can be an ordinary suit filed, but not under an election petition. We'll keep it after next Friday. Next Friday.
No,
Next Friday we'll dispose of how many you have not assumed charge.
Yes, yes,
Musharraf?
yes, in charge.
Mr.
Charge
Musharraf
only
Hossain's
assumed,
client is in charge.
In charge, my lord.
How long are you running Panchayat?
No, for 1 year, 3 months.
1 year, 3
1 year,
months.
3
already. Not
Even
very-
they will not able to face the no
No.
participation. They have
What
got the
we
remedy
will do,
remedy also.
we
there.
will set aside. We will set aside this election because this election was under very violent
Possibly,
conditions.
my lord, after
Musharraf Hossain, listen to us.
Mokaram.
More. What we propose to do,
Lordship.
because of this, you understand, there is no verification papers. Everything is torn. You may argue that you won clearly.
But it is a clear stand, my lord, before the United Single Bench, my lord, that after the declaration of the my lord, result, that this would arose.
If
The
that
after
cannot,
declaration, that is the clear averment made by the video commission.
maybe, even if it is,
So when the it is
it is
absolute
their
absurd story.
case, it is their case that the election was unfairly declared.
Yeah.
It was held unfairly. And now there is no document to verify whether the declaration was properly done or not. Do you understand what you're saying?
Absolutely.
Let us say there are 10 voters, 7 in favor of Mrityunjay's client, 3 in favor of your client, 7-3 declaration is one who is 3 is elected. So the declaration is wrong. He has a right to judicial review. And the judicial review requires verification of records which are to be maintained for a period of time. It is not maintained. Why? Because of violent conduct. If this is a violent conduct which impacts even post-declaration, materials which stand in the way of a fundamental right to judicial review, does not that decision become suspect? We cannot decide whether the verification was right or wrong. So in this situation, it would be prudent to direct for a fresh election. You have a fresh election. You are popular man. You will get your election. Again, you will be elected. But here, under these suspicion circumstances, if people's representative, even at the panchayat level, as Pradhan, people will always say that he won through force, violence. Why should you have that slur on your head? All right.
Yeah.
Next Friday.
Obviously, lordship.
Lord, item number 6, my lord, I beg to appear for the appellant. So this matter, your lordship would recall, my lord, relates to, my lord, that Newtown Society, my lord, the election dispute.
So,
With respect to, my lord, your lordship was pleased to hear out the matter for some time. Yes, my lord. Item number 5, my lord.
we have forgotten major part of this objections. We have to fix a date for hearing. What we propose to do
Next Friday, Lordship
Next
fix the
Friday-
previous matter. Friday week, if Lordship fixes
Friday
it,
week we are not there.
not there. Well, Friday thereafter.
February. Sometimes in February we keep it. So that one day we will, first half we will do, and then we will, maybe 1 day or 2 day we will.
My
do.
lord will give.
Lord, only one thing I was, Lord, very innocuous prayer, Lord. There was a subsisting interim order in my appeal with respect to maintenance of status quo as regards the preparation of electoral and voters, Lord, those disputes. Lord, let that be extended. Lord, I had obtained that injunction, Lord, from the previous division bench.
And that will go.
Unfortunately,
Whatever
because the
is
matter
there,
was-
it will
My
continue.
lord, it has lost its force, my lord. The main contention is whether the building itself is legal or not.
No,
That
what
lordship
is
will
it?
that
decide.
is his appeal. That is the
Correct.
honest-
So,
I
so
under-
we will see. You are not required to go into election now. If you require an extension, take out an application. We will consider.
Wait, I'm great.
Whenever is convenient, lordship will fix it, I shall be.
This one. We keep the 7th or 14th. 7th?
7th of February, my lord, oblige.
7th February.
7th February.
7th on prayer of the parties fixed on 7th.
Great.
Both 4 and 5.
All.
Great.
4, 5, 6.
4, 5, 6.
Other matters 2 p.m.
Well, I am for the petition. But last
Also, they have given that it belongs to this present petitioner.
All right. Report is placed on record. The report indicates that the FX website of Public Service Commission West Bengal was created. In the said website, name of the de facto complainant as a successful candidate was published. On the strength of such fictitious records, he was induced to make payments to petitioner and others.
Fake appointment letters was issued.
Fake appointment letters had also been issued. In light of the aforesaid materials on record, it does not, it rules out the possibility of involvement of public servants in the crime. Accordingly, investigation may be carried on by an inspector of police, full stop. However, the materials collected during investigation are clinching and implicates the petitioner in a cyber fraud. Accordingly, we are not inclined to grant and reject. Next.
The complainant earlier also made the same allegation. De facto complaint also appeared in this case. Civil case also pending, restrain us not to enter into the property, page number 41. An earlier occasion, your lordship granted bail with the condition we are complying. The same self action.
Order.
Order, my lord, page number 14, PO1, my lord.
Petitioner number 1 has 3 cases, including this present.
One after another case
One of
my lord, in a similar circumstance, my lord. Same dag number, my lord, fill up the pond and forgery the deed. Lord, page number 41, civil court order. 27%, my lord.
Petitioners content that there is a civil suit pending by and between the parties. An order of injunction has been passed therein. Series of criminal cases have been lodged on similar allegations. Series of criminal cases have been lodged. In one of the cases,
Subject to your lordship's correction, my lord, not similar allegations, my lord. That was for filling up of pond, and this here, my lord, the petitioner number
attempt to rape.
55, no, my lord. Forged the documents,
Same dag number, same.
prepared a deed, and sold one property twice, my lord.
Same property, my lord.
By
Earlier occasion.
Signature
A
of
civil suit is pending between them.
They are the land shards of the.
Series of criminal cases have been lodged. In one of those cases, they have been granted anticipatory bail. They pray for anticipatory
Lordship, may be permitted to place only 2 lines, Lordship. The petitioners are the land shards of in the locality, and they are, by executing this false and forged fabricated deeds, Lordship, they are trying to grab our property by various
Right.
means, Lord.
Petitioners, lawyer for the state submit, petitioners had forged and fabricated sale deeds and are claiming title on the property. This is also corroborated by learned counsel for de facto complaint. We have considered the materials on record. A civil suit is pending by and between the parties. On the allegation that petitioners, an order of injunction has been passed therein. Title to the property is the subject matter of the said suit. The alleged forged deeds have been produced before the court or with you.
no, that has been seized and it's
Alleged forged deeds have already been seized by police. Full stop. In light of the aforesaid circumstances, we are of the opinion, though custodial interrogation is not necessary, petitioners are required to cooperate with investigation in accordance with law. Once a week, the earlier conditions same. Next.
And I am appearing on behalf of the petitioner. My complainant provided our documents and fingerprints to 2 unknown persons. Subsequently found, my lord, 20,000 withdrawal from the bank account, my lord. My lord, kindly appreciate the petitioner completely transfers from the co-accused statement. And though there are
We
punishments,
have considered the materials on record. Petitioner is a member of a gang who had utilized the fingerprint of the victim to draw money from his account. Custodial interrogation would unravel the ramifications of the crime and lead to recovery of stolen cash. Hence, we are not inclined to grant it. Petitioner has antecedents also. Next.
So for 20 is concerned, if your lordship kindly take up this matter on 14th, because one of section 15 and 16 of the Petroleum and the Pipelines Act, Minerals and Pipelines Act, there, we need some instructions. Kindly on 14th, man.
Please give a notice to who is the complainant.
One of the complainant is
Please.
one Arimdom Das, General Manager Operations, Pump Station of the Oil.
This is Indian Oil, no?
This is Indian.
So please give notice to the complainant.
my lord, I am for the petitioner, my lord.
We know 14th. Next.
14.
Oil.
Well, I'm not agree for the de facto complaint, my lord.
First.
Petitioner for the de facto complaint, my lord.
Petitioner assaulted the complainant husband on the this
They are having a
allegation assaulted the complainant husband, my lord, on the dispute of demolition of the drain, my lord.
Stabbing and laceration on the head
and chest.
And my lord, Accused number one granted antecedent bail from the trial court, my lord.
Who assaulted?
My lord, page 30, he has taken three names.
Three.
Mansoor
Uh,
and Hannan and Salman.
Monsoon, Hanan. So we reject 1 and 5. We have considered the on record injuries are grievous and on vital parts of the body. Victim. It's a statement of witness.
The doctor.
Statement before the doctor discloses shows petition number 1 and 5 assaulted the victim. Hence, we are not inclined to grant anticipatory bail to them, keeping in mind extent of complicity of petition number 2, 3, and 4 in the crime. We are inclined to grant anticipatory bail to them. Next.
My lord, I am for the petitioner. My lord, 22, 36, and 39 out of same CD, my lord. And my lord, three accused persons.
Your lordship has rejected yesterday one of the accused was responding.
My lord, over a property dispute, my lord, an altercation took place, my lord. And my lord, as a result, my lord, the father of the de facto complainant, my lord,
What is the involvement of these persons?
Seven accused persons are earlier arrested.
There are eyewitnesses?
Yes,
They have
named 164 names. But your lordship rejected yesterday's.
All right, our rejection is secondary.
These 4 persons are named.
All right, petitioners have been named by
lady, my lord.
eyewitnesses, named the petitioners as members of an unlawful assembly, who members of a group who had assaulted the victim, resulting in his death. Keeping in mind the gravity of offense and the incriminating materials implicating the petitioner in the crime, we are not inclined to grant anticipatory bail. Same order in 36, 36 and 39. Same order as in item number 22. ঠিক আছে? 36, 39. Yes, next matter. 23.
I am for the petitioner. Case under section 307. Injury is simple. Others are on anticipatory bail.
We have considered the materials on record. Injuries are simple. Co-accused have been granted anticipatory bail. Accordingly, we are inclined to extend same relief to petitioner. Next.
I was praying for liberty to correct the cost title. It should be 110 BNS.
110 BNA.
My lord, here, my lord, my lord, 308. My lord, the allegation is over a common passage. My lord, the de facto complainant, they filed a suit. But in that suit, my lord, their order of injunction was refused.
Okay, we have considered the materials on record. There is dispute between parties over use of common passage. A civil suit is pending. Injury does not appear to be grievous. Accordingly, we are inclined to grant anticipatory
That
bail. Liberty to correct.
Great.
Next.
Lord, I am for the petitioner. Lord, the allegation under section 85 and 82 of the new act. Lord, 490.
Years after marriage.
Lord, this marriage.
2 months. Then.
Lord, the mother-in-law. Lord, the victim had committed suicide at her parents' house, father's house. Lord, the husband was arrested. He is in custody. Lord, the father-in-law. Lord, arrested. Lord, the father-in-law granted bail. Lord, the learned judge, while granting bail, categorically observed that the allegation is against the husband. He is the principal accused. He is in custody. This petitioner is the mother-in-law.
Yes,
Not 164 statement of the mother of the victim.
She went to her father's house and after 5 days she committed suicide there.
Just thrown out of the house. The allegation.
Page 78 is the 164 of the sister matter.
Who accused her of theft?
The altercation between the husband and the wife
On that night.
on that night, and the wife, on the next day went to her father's house.
Wife was in the father's house. She was driven out on the false accusation of committing theft. Then she was there on the night. There was an altercation between the husband and the wife, and the wife commits suicide. Petitioner is the mother-in-law of the deceased wife. She contends she has been falsely implicated. She prays for anticipatory bail, and a lawyer for the state opposed the prayer. We have considered the materials on record. Statement of the mother of the deceased show there was a love affair between the deceased and her husband Partho. They married. After marriage, she was ill-treated and driven out of the matrimonial home. Subsequently, she was again brought back to the matrimonial home, but she was driven out on the accusation of committing theft. On the fateful day, her husband abused her filthily, and she committed suicide. The proximity, conduct of the from the aforesaid narration, it appears, though there are allegations of general allegations of torture against the mother-in-law, that is petitioner, the immediate cause which triggered suicide are the abuses hurled by the victim's husband. In light of the aforesaid circumstances and the extent of complicity of the petitioner in the crime, and as offense, and as there is no chance of abscondence, we are inclined to grant answer. Next. Next.
Lordship, I am for the petition. Lordship, offences under section 326, 307, 34 of the Indian Penal Code. After 3 months, 18 days delay, they were also lodging the first information report.
Sonali Das.
Accidental burn injury.
What accidental burn injury?
Yes, my lord.
Why? How burn?
164 is stated, 161 is stated otherwise.
So otherwise, let us see.
3 months, 18 days delay, lodging the first information report.
Petitioner submits there is inordinate delay in lodging first information report. Victim suffered accidental burn injury. Subsequently, they were falsely implicated. They pray for anticipatory bail, and a lawyer for the state opposed the prayer. We have considered the materials on record in the FIR, as it is alleged. Petitioner and others had set the victim on fire as he had demanded money, as he had demanded outstanding dues. However, in the medical report, history of injury is noted as accidental burns. There is delay in lodging FIR. In light of the aforesaid dichotomy with regard to the genesis of the incident and delay in lodging first information report, we are inclined to grant that.
Grateful.
Next.
Lordship, I am for the petitioner. Petitioner had an extramarital affair with the husband of the de facto. And on that issue, there was a scuffle between the petitioner and the de facto complainant.
All right. Injury?
Yes, my lord.
Well, thetatin is there, and one of the fetus was inactive, and abortion was. The YouTube report and the USC report is page number 24 and 26.
Petitioner contends there was a fight between the parties. Allegation of miscarriage due to assault is incorrect. She prays for bail. Learned lawyer for the state contends petitioner had an affair with the husband of the victim. Over this issue,
Well, not the petitioner.
Petitioner. Petitioner. Sehenara Bibi.
Sehenara.
Elias.
Adlosi.
She is the mother of that lady.
Oh, Adlosi is the mother of the.
Lordship. No, enar সাথে affair ছিল. She is the petitioner.
Well, from the CD, I have seen that.
Let us see. Show us the statement.
164 statement at the. Well, 161 statement was page 10.
Page 10.
You see the map. Sagirata main.
Sagirata to me.
মেয়ে তো করেছে মেয়ের সাথে
এইটাই পিটিশনারের সাথেই তো অ্যাফেয়ার
এফআইআর এ তাই বলছে সবই একই রকম নাম
আদলসি বিবি আর এটা তো এলায়েন্স
হ্যাঁ এলায়েন্স আদলসি
হ্যাঁ আর সাজিরা হচ্ছে পিটিশনারের মেয়ে
হ্যাঁ
অ্যাফেয়ারটা তো ছিল পিটিশনারের সাথে
অ্যাফেয়ার ছিল আর কি
ঠিক হলো
কি বললাম Petitioner's daughter had an affair with the husband of the victim. Petitioner, along with her daughter, assaulted the victim and her mother-in-law. As a result, she suffered miscarriage. We have considered the materials on record. Injury reports show injuries.
Page 18.
Injury reports do not disclose any external injury. Full stop.
USC report page 24 and 26 is the final. 26.
24,
26. And 29 miscarriage. Abortion.
And there was a hit on the stomach, but there's no bleeding. No bleeding. This is normal miscarriage. There's no injury. Medical report with regard to abortion does not show any injury. It appears to be it does not show injury or signs of abortion due to assault. Under such circumstances, we are inclined to grant absolute review. Next.
28, my lord, I am for the petitioner. My lord, 67 accused persons are arrested, my lord, on the basis of the sumoto complaint of the, my lord, police. And against me, the allegation, page 14, second paragraph, that I, the leader, during investigation of accuracy, revealed that they have assembled themselves in front of Sampur police station, my lord, in response to call of Dr. Aftab Mullah. I am the Aftab Mullah, my lord, again, my lord, allegation against the petitioner that he is at his response, my lord, incident took place, my lord, police station, my lord, Gherao, some police person injured, 307, and also 353. Yes, my lord. But I am a reputed lordship. Only one thing, my lord. I am a resident of Bulgaria, and I am a leader of one particular political party, my lord. And not only that, I am the owner. I am the owner of a nursing home. That papers with me, my lord. I am a owner of a nursing home, my lord. That paper I have stated, but my lord, I am paragraph 2. I have stated, my lord, that I am a owner. It is in two. I am an owner of a nursing home and far away, my lord, Ulveria to Sampur. My lord, thereafter, on the basis of the co-accused statement, my lord, the petitioner has been entangled in the instant case, my lord.
FIR name.
FIR name when? My lord, page 14, last.
My lord, he was present, my lord.
Where is he present?
My lord, CCTV footage is there.
Where is
On
CCTV
that
footage?
basis, my lord, he was, my lord.
Where is the
notice was-
CCTV footage that
my
he
lord,
was
CCTV
present?
footage, my lord, page 284 is the Caesar list of CCTV footage.
Correct. So who saw the CCTV footage? Verify the CCTV footage and show that petitioner was present.
My lord.
Report with regard to CCTV footage be verified to show the presence of the petitioner as a member of unlawful assembly.
My lord.
Let the matter appear on Tuesday.
My lord.
If you are there, then
my lord,
yes,
rejected, my lord.
show it to him. Bring out the snapshots of the CCTV footage where the petitioner is identified, right?
My lord.
And place it before us.
My lord, it is-
Next.
Get fully honest.
This is what? Third category of political.
My lord.
First, second, third.
My lord.
কি বলছে থার্ড ক্যাটাগরি অফ পলিটিক্যাল
Indian secular fund.
Indian secular.
And also, my lord.
First category, second category, now third category.
My lord. Get
Yes.
fully honest.
my lord FIR against 24%, my lord,
Like
under
we have
section
considered the
379,
materials on record,
436.
though it is alleged that houses were burnt, no one was injured. Keeping in mind the aforesaid fact, we are inclined to grant answer.
Grateful.
Next.
I'm for the petitioner, my lord. The allegations are under 341, 323, 325, 308, and 34 of the IPC.
Injury,
It's a
Mr.
family dispute. And the
Incident
principal
arose
accused
out
is
of
on
a family dispute. Injury report does not show no serious or grievous injuries. In light of the aforesaid fact, we are inclined to grant answer. Hello. Next.
May it please the Lordship, Lord, I am for the petition. Lord, upon an application, under 156 clause 3, Lord, as per the new act, my Lord, 109, 115 to 117 to 126 to 35. This has been initiated. Now, my Lord, prior to this, my Lord, this is a long-time family dispute. It is amongst the family members. The two complaints were lodged by the petitioner number 3 against the de facto complaint, which, my Lord, at P1, and the second one is at P2. My Lord, now
Family member is good, but the problem
what has happened on 23rd? I'll tell you, Lord.
The nature of injury.
4 persons were injured.
How much?
3 appears to be simple. But one lady sustained injury on the head. 2 stitches were given.
But your lordship kindly sees that injury in respect of the de facto complainant. The male members took active part. In respect of the female members, I have nothing to say. Your lordship kindly see how the de facto complainant sustained injury.
Deepest respect, my Lord. I'll show my learned friend, my Lord, what injury I have faced. I have annexed that.
Not only.
My Lord, I have annexed that. Kindly see, my Lord. My injury also in the cases which I have prior to that, and they come after, my Lord, 1.5 months.
Stitches also.
No, not 7. Only 2 stitches.
Fracture is there. Anjali Chakraborty fracture. Mildly displaced commuted fracture of the right zygomatic arch.
Lordship will kindly reduce from 51 to 54.
Head scalp fracture.
My lord, annexure P3, mine also, my lord. I've annexed I have also been injured.
What you are injured? P3.
I have annexed those documents.
Page.
It starts from 23, my lord.
Starts with
23.
23. In the same incident?
Yes.
When he is sustaining it.
In the same incident?
Yes, on 23rd of October, my lord, the incident had happened.
And you are getting 20 and nothing is happening. Soft tissue, skull left.
But it is a fire.
So, you are who?
My lord, I am Bijoli, my lord, the petitioner number 3.
This is Bijoli.
Bijoli Chakraborty.
Therefore, all the women members are getting assaulted.
My lord, they are also all petitioners, female men.
This can be mata mein injuries. But Bijoli Chakraborty, that is in a different case, na?
That what we have initiated. My lord, the prior to this.
So not on that day. This incident, the FIR that you are showing,
yes,
is 2610.
Yes.
And this is occurring
on 23rd of October 2000, as they have alleged.
On 23rd of October.
Now, my lord, there are two complaints.
On 27th also there is a complaint.
Yeah, both of them are fighting with each other. Petitioners are family members. There is continuous disputes and quarrels among them. Series of criminal cases have been registered. Both parties have suffered injuries. Though one of the injuries appear to be grievous, the same requires to be assessed in light of the attending circumstances relating to continuous hostilities between two groups, between the family members. Custodial interrogation for progress of investigation is not necessary, and petitioners may be granted anticipatory bail subject to condition. Petitioner number 1 shall meet investigating officer, 1 and 4 shall meet investigating officer once in a week until further notice.
Deeply obliged.
Next.
That's it.
32.
The wife went away from the house in 2020. Well, she didn't return. I filed restitution of conjugal right on 22nd of August. 25th, coming to know of the said fact, 25th, register FIR.
General obvious allegation 307 omitted from the charge sheet, only 498.
We have considered the petitioner contends that the de facto complainant wife had deserted the matrimonial home
in 2020.
In 2020, subsequently, criminal case has been registered. Petitioner prays for, you are the husband.
Husband. Full accusation.
Petitioner prays for anticipatory bail and a lawyer for the state opposes the prayer. We have considered the materials on record. Allegations of cruelty are general and omnibus. It is contended de facto complainant wife had left the matrimonial home in 2020. Under such circumstances, we are inclined to grant anticipatory bail subject to conditions. Meet investigating officer. Next.
Charge sheet to hoga. Charge sheet.
I am for the petitioner. On
Meeting.
3rd of November 2024,
Meeting.
one Preeti Ghosh, the minor daughter of Proceedings Ghosh, who is also an accused in this case, was missing. But on 3rd November 2024, the said accused person, Proceedings Ghosh, lodged an FIR against the de facto complainant herein and his minor daughter. But on 6th November 2024, the minor daughter, named Trisha Vishwas, committed suicide. But on 6/11, this instant case was started against 6 persons, including the present petitioner herein. But the present petitioner, firstly, I submit, he is in no way related with the other accused persons. But your lordship may kindly see, said Prosenjit was arrested on 7/11 and on 21st December, he was enlarged on bail. But from the bail order, what he find, the minor daughter Preeti Ghosh has made 164 statement with the learned court below. She had allegations against the minor daughter that this is hearing,
And the de facto complainant?
Want the earlier case, Shuchit, we want the earlier case lodged by Prosenji. Please call for the case. Yes. Monday, Tuesday?
All right. No. I'm grateful, my lord.
This is the father of that.
ওই কাগজটা কি থাকে ভেতরে? থাক।
The father of the prayer for with certificate.
নামগুলো দিয়ে দাও, সবার নাম দিয়ে দাও। 33 নাম্বার।
Where is your son?
For I am for the petitioner, my renewal, my renewal application, principal accused has acquitted.
Petitioner has been absconding for a protracted time. Proclamation was an attachment has been issued. Petitioner contents in the meantime principal accused has been acquitted. This issue may be considered after the petitioner surrenders before the trial court. Now, this issue cannot be a ground to reconsider his prayer for pre-arrest bail in light of the fact that he had absconded and has been declared as a proclaimed offender. Rejected. Petitioner renews his prayer for answer. Next, learned lawyer opposes the plea. Next.
Lord, I am for the petitioner, my lord. 316 subsection 3 of the Bharatiya Sanhita, my lord, that is 407 of the Indian Penal Code. The allegation is, my lord, on 22nd of September 2024, the de facto complainant company has booked and consigned for transportation. Yes, my lord. For transportation from Holdia plant to, my lord, to Bihar through one broker, Chandan Maji. I am the owner of the vehicle, my lord. Lord, I have annexed the document, my lord, on the relevant date. On that particular time, my truck was plying in the state of Assam. At page 18 onwards, my lord, I have annexed, my lord, annexure P3. Page 18 onwards, my lord, the parking slips.
Then how can your truck be booked by...
that I do not know, my lord.
That you do not know. Go to custody. That you do not know.
My lord, that is my...
All right. We have considered petitioner is the owner of the truck. The truck was used to... had been hired to carry the stolen articles. Stolen articles have not yet been recovered. Custodial interrogation for recovery of stolen articles is
vehicle was booked through a broker, my lord, not by me. My vehicle was never used, my lord.
If never used, then you are in trouble. If you can show that it was broker, you have no control, it's something else. Rejected. Vehicle in Assam.
Well, I am for the de facto complaint.
420-406, during COVID, complainant handed over a dumper to me in lieu of 4.5 lakhs. There was an agreement that out of remaining 48, I'll pay everything. After paying 25 installments, they said that okay, we'll give you this dumper. Thereafter, they didn't hand it over to me, those papers. So I have paid, I have stopped paying. A surfacing proceeding has been initiated against them. Now they have come up with a new story that another vehicle he has handed over to me, and I am not paying.
Who had purchased the vehicle with bank loan?
My lord, my client.
You purchased the vehicle with bank loan. You let out
my lord.
Hire.
My lord.
He is not paid the higher charges.
Arunachal Pradesh now.
Huh?
2 dumpers now at Arunachal Pradesh.
2 dumpers at Arunachal Pradesh. Produce the dumpers.
Produce the dumper. No problem, my lord.
Produce the dumper.
Second one is story. First one, second, take it from me.
Where is the delivery of the second dumper?
Those agreement, my lord. My lord.
There is an agreement, my lord. This is regarding the first agreement. First agreement.
Another what agreement আছে একটা কি দুটো আছে তো
First
One agreement only.
6372 and
6372 agreement.
and another
Another is your imagination.
no my lord that agreement my lord what I'm paying for my lord one day accommodation agreement I produce my lord. My lord I produce that agreement my lord.
And a forced document you will produce.
No.
Produce the agreement.
The recovery of dumper is required.
Recovery of first this dumper be produced.
My lord.
You bring that dumper. Huh? Petitioner contents a dumper bearing registration mark WB41J6372 had been handed over to him on hire. No, he had paid higher charges. Full stop. However, proceedings under SURFACE Act has been instituted against the de facto complainant and he has lodged criminal case. He prays for anticipatory bail and a lawyer for de facto complainant submits 2 dumpers were let out to the petitioner. He seeks time to produce documents with regard to the hiring of the second dumper. Matter will appear 2 weeks hence. In the meantime, petitioners shall hand over the first dumper to the investigating officer. Subject to the aforesaid, petitioner shall not be arrested for 2 weeks or until further order, whichever is earlier. Now you manufactured your document for second dumper. Next.
For the petitioner, my lord, 498 is 302, but actually victim committed suicide. Co-accused on same footing was granted anticipatory.
Who are you?
By the villagers.
Villagers. All right. Petitioners are the villagers and it is contended they did not play any role in the matrimonial life of the couple. Victim committed suicide. Co-accused similarly circumstanced with the petitioner have been granted pre-arrest bail.
There was an affair, my lord, with the petitioner number 2's husband with the deceased.
Right. Accordingly, we are inclined to grant anticipatory. They pray for anticipatory bail and a lawyer for the state submit. Petitioner number 2's husband had an affair with one's husband had an affair with the deceased. We have considered the materials on record. Allegations against the petitioners are general and omnibus. Co-accused similarly circumstanced with the petitioner have been granted anticipatory bail. Accordingly, we are inclined to extend the same privilege to the petitioners. Next.
Okay, I'm for the petitioner. Allegedly, the cause of action started in 2013. 2013 to 2018, kindly consider paragraph 5 of my petition. 2013 to 2018, I was the employee of the de facto company. Allegation is that during that period, the accounts which I was supposed to be, take care of, I was supposed to deliver the raw golds. I was supposed to take out the raw golds from the showrooms and then the finished gold at the
2021, you are absconding for 3
from
years.
21, my lord.
I have not absconded. Kindly come to page 11 for once. This is the fresh warrant that was issued on 25th. The warrant that was issued was against another person and it was addressed to Ranchi. I don't have anything in Ranchi. So a fresh address was given in 25th of December.
But from 21, when was the charge sheet filed?
No, charge sheet has not yet been filed. Investigation is going. Now,
My lord, initially raid was made in his address.
Let us do like this. Let him place the papers before your investigating officer.
My lord.
All right. Petitioner contends that he had resigned from the employment of the complainant in 2018. Thereafter, he started his own business as goldsmith. After a lapse of 3 years, FIR has been registered alleging misappropriation of gold. He is ready and willing to cooperate with investigation. Petitioner shall meet the investigating officer and hand over relevant documents in support of his plea. Matter with
one line, my lord. The entire accounts is with the de facto complainant.
And that shows misappropriation, my lord.
That
So, I will cooperate.
and explain that.
Yes, ma'am.
Petitioner shall cooperate with investigation and explain alleged discrepancies in the accounts of the de facto complainant. Matter will appear 2 weeks hence. Petitioner shall not be arrested in connection with this case for a period of 2 weeks or until further orders, on condition that he shall meet the investigating officer as and when required, and not less than once in a week.
Great.
Next. अब बहुत दिन हो गए.
Yes, my lord. The
306.
306, my lord.
Then
But can you see the allegation? It is stated that the petitioner was on a call with the daughter of the de facto complainant, and the petitioner
Just-
called the father of the de facto victim, and
age.
Age 19 years, my lord. One
here
line.
is the love relationship.
That is admitted, my lord.
You get to marry.
But just before
if one call makes her jump.
Yes, my lord.
That is not.
My lord, at the date of my lord, the suicide, my lord, just 2 call, my lord. He has received 2 call. Thereafter, my lord, he committed suicide.
So how do you know the parents were not abused her? What is the father went and say, why are you talking? Come down. Petitioner submits he had a romantic relationship with the victim girl. Parents did not agree to the relationship and used to scold her. As a result, she committed suicide. She prays for anticipatory bail. A lawyer for the state contends petitioner was heard talking with the victim girl just prior to the commission of suicide. We have considered the materials on record, including statement of witness recorded before magistrate. This is mother, na?
Mother.
Statement of the victim's mother before magistrate. In her statement, she stated that victim's father saw her talk with the boy. Full stop. Talking with the boy. He told her to come downstairs. Thereafter, the victim went on talking with, in spite of that, victim went on talking with him, with the boy. It is contended that the victim may have been scolded because of her conversation and committed suicide. The reason for commission of suicide is unclear, as no suicide note was left behind by the victim. Under such circumstances, we are inclined to grant anticipatory bail. You are filing application for bail in Jalpaiguri, number of bail applications, I am told.
No,
अपूर्व बोल रहे थे आपके
Well, the petitioner and her husband, they cultivate lily flower.
What flower?
Lily flower.
Lily flower.
Yes. And previous day, they have cut down all the lilies. So the next day, quarrel started. Petitioner's husband, this petitioner and family members, there was a free fight, and a lady received some injury.
We have considered the materials. Petitioner contends that there was dispute between the petitioner
And the neighbor.
and her neighbor over cutting of flowers. She has been falsely implicated. She prays for unspeakable and a lawyer for the state. Or this the prayer. We have considered the materials on record, including the injury report. Incident occurred in the court on the spur of the moment as not is a and is not a premeditated one. Under such circumstances, we are inclined to grant unspeakable. Next.
Highly obliged.
Three 307 of the Indian Penal Code. Over the incident, there is a case and counter case.
My
Your Lordship kindly see
My lord, injury is page number 35. My lord, simple injury, but my lord, there is no counter case, my lord. No, there is no counter case. My lord, kindly see, my lord. My lord, kindly see the FIR, my lord. Kindly see. There are Rajat Mandal and someone, my lord. We are not Rajat Mandal and we are not accounted with Rajat Mandal, my lord. Sit down.
Petitioners here are mother-in-law and brother-in-law. My lord had pleased to grant anticipatory bail to other brother-in-law. I am claiming parity. Page 6, my mother-in-law and brother-in-law. Anticipatory. Macho.
Lordship 45, I am for the petitioner. Offences under section 21C and 29 of the NDPS Act. Petitioner not named in the
Wrote the date of the registration of FIR is on 17th of December 2024. Only the last 23 days, what the investigating agency has investigated, that the car in question, the offending vehicle, is in the name of the petitioner. Deeply.
My lord, the allegation is this: in the month of September 2021, the complainant allegedly invested a certain sum to a company, Ascan Limited. My allegation against me is this, that I have asked him to deposit the money as there. He admitted in the FIR that he withdrew some amount of money from the company periodically. Subsequently, in the recent past, the account became inoperative, for which he has initiated this complaint. But Millet, there is another story of this case, Millet. He took loan from me for which he has issued a check. The check was dissolved. Millet, this. I mean, Millet, I have no connection with this Ascan, Millet. I have no connection. And according to him, I have asked him, but the story is something, Millet, he took loan from me. I have annexed the documents also, Millet, that the check was dishonored, for which I had issued a notice 138. And he admitted that he withdrew money therefrom.
Well, in the case there is nothing, Lordship. Lordship, kindly see that only 3 statements, Lordship, and nothing has been seized, Lordship. I can, because I have to. I have, Lordship. Yes, Lordship. But there is no documents, Lordship. Nothing is seized, Lordship. Yes, Lordship.
These are applications for bail, which have been assigned to your lordship. Well, that matter. Your lordship's orders was forged. Now, my lord, here the son of the accused who was granted bail, he's number 1. And number 2, my lord, is the learned advocate. My lord, it's in Calcutta now. It has been transferred as per your lordship's orders. My lordship reads your lordship's order. My lord, since November 23. 21st of November 23. A magistrate tribal case, my lord, I leave it.
1 year, 1 month.
No. Kindly peruse your lordship's last order. Last order. But where your lordship granted bail to Dilak Pal? Which order?
The last day when the matter was adjourned.
এখানটা কবে হয়েছিল? Oh, মানে that is in respect of Ajijul, this brother-in-law, the son-in-law of the main accused man, Ajijul Sheikh.
এখান থেকে রিলিজ করেছিল
7/12/24 was the last order wherein your lordship.
Well, arrest 23rd of November. 21st of November.
My lord, in your lordship's order.
My lord, your lordships on this date, your lordship has asked the status report to be filed on the 14th of January. Charges are to be framed, my lord, but I gather there is a dispute regarding 207 papers. And Mr. No, I'll tell you what. It is being given today itself. The judge has ordered and it will be given today. Well, let it be on 14th when the other matter is fixed. Lordship keeps it.
We want the trial.
Right. Both in respect of the three matters. Let that come up on 14th. So, my Lord keeps it. I'll leave it. Right, man. Come on, 14th. By today, 5 o'clock, they will give it to us.
In Bahrampur, till date, whatever charge sheet and supplementary charge sheet we have filed, that is the reason why I have produced all the Bahrampur court orders. But all have been received by them. Now, when this on the last date, and I am serving them, giving them again.
Well, he's giving it today.
Giving them again, so that this dispute they doesn't want to.
Judge, right.
By today, I will be giving.
Your Lordship will come back, then come. Right. I am grateful to you. No more, no more, no more. We will not complain about 2 and 7 anymore, because he is giving it today itself, all the people.
This next date is on 20th of January. So let the matter come up after 20th of January.
It's fixed on 14th, Haji June. After 8th of February.
On 14th of February.
Grateful.
Okay.
Right, one.
So that on 20th of February. You can spend 1 month. In the meantime,
Proceedings to start.
Court steps to order the trial on a date.
Yes. Every takes order.
Record anything.
You will Lordship record it. Oh, acha. I get you, Your Lordship. Your Lordship proposed orders on 14th, Your Lordship has told us today. Grateful. আর তো নেবেন ওই নম্বরটা হচ্ছে সিআরএফ সিআরএফ আমার মেমোরিটা একদম গেছে
এই অর্ডারটা কোথায় গেল? এই যে লাস্ট
তো মাই লর্ড
by CRM DB 2707 of 2024. On the last occasion, when I had a meeting regarding this with the Registrar General, the Registrar IT was also there and the Registrar Admin. But they were developing something with NIS or NIC. Proposing all the proposing something. Yes, Mr. I think that. No, I have matter.
Cancellation.
$49 and $50 million. Millard, I appear on behalf of
But I am for the petitioner.
Millard, your lordship wanted the compliance report. But I am intervener here in this case. I am the victim. I am a witness
In another
one
case.
case. My lord, after my lord anticipatory bail, he my lord assaulted. I am my lord Gibeah's heart. A case has been started. I am filing opposition. My lord, yes.
Opposition by intervener. I am petitioner. Our affidavit have been exchanged.
Appearing behalf of the accused. He is also
My lord. Yes.
one of the matter and subcontract. After this opposite party shall fight state shall also fight the court.
Status of investigation.
And my lord, kindly status of the my lord
Investigation.
Yes.
Status of the investigation.
Next matter.
Keep local status.
Next matter.
49 and 51 I am for the petition. Well, this is my affidavit in reply, my lord.
Paper.
I am for the petitioner. It is a cancellation of bail. The opposite party has assaulted the petitioner after granting of anticipatory bail.
Yes, my lord.
Yes, they have filed. We don't have any reply. We only
53 mallet I'm 53 mallet I'm for the petitioner because my affidavit service.
On 53 on
the 34 mallet why
Just a second. They have assailed two different orders in one single petition.
ওরা রিপোর্ট দেবে তো স্টেট আমাদের তো কিছু নেই স্টেটের রিপোর্ট দেবে The item 54 on the last occasion, a report was called for by Lordship. My lord, I've sought cancellation because of the post bail conduct of the accused persons.
This is the report. My lord, report regarding conduct. They have filed a report that he was threatened. My lord, he was. This opposite party was the petitioner was threatened.
Not the petitioner. The opposite party was threatening. Ashib, may I get a grateful man?
My lord, I am telling you 1 week time.
Report kept on the record.
Rejoinder of the record. বলে দাও রিপোর্টের রিজয়েন্ডার
My lord, I want to copy.
Well, I have to respond to my lord. I am praying for my lord 2 weeks time to file reply, my lord. Opposition, my lord.
Last occasion they have preferred leave to file opposition. Last occasion, my lord, they have preferred leave to file opposition.
কিছু হলো
My 59 days. My lord, 59. Not today, my lord. Not today. Not today.
And I'm for the opposite party number 2.
My lord, 60 I am for the petitioner, my lord. On the last occasion, my lord directed On the last occasion, my lord, Showminson directed to submit a report before IU, my lord, to produce the original documents.
I have handed over the original document to the IU.
Grateful, my lord. 61 is the same matter, my lord. Dada,
Grateful.
My lord, I'm led by Mr. Chatterjee. My lord, this is my affidavit of service. My lord, there were two addresses, and we have served in both of the addresses. On one, it was logged. Yes, my lord. Yes, my lord. My lord, but the service is good.
I'm for the same.
Grateful, Your Lordship.
Lordship 66, I am for the petitioner.
Yes, ma'am. 68. But I'm led by Mr.
I'm appealing
this much. Is affidavit of service. No, I'm not service. No, supplemented. তোমারটা কোথায় সার্ভ করেছি এভিরিওয়ার সার্ভিসেস Yes, my lord, it is served. Served, served.
Statehood in the meantime inform. How state করবে তুমি করেছো তো?
For the petition. But I saw that service has been effective. This is I'm happy to do a service has been Great.
71, I'm for the petitioner, my lord. There is a direction for service, but I could not service. Sorry, my lord, once more. Outside.
I paid for the opposite party number 1.
I'm for the petitioner, my lord.
420, 406 joint property. I wish our part initiated 420,
75, I'm for the opposite party member. Grateful.
I am from the affidavit of officer, my lord.
So, madam, I'm led by Mr. Banerjee.
Sanjay Banerjee. Last time. Reply also made ready, my lord. I do not know. Briefly, please.
My lord, may consider keeping this a little earlier in January 26.
My lord, 77 is the monthly list of 77. I am at
My lord, 78, I'm appearing for the petition led by Mr. Arun Kumar Maiti. I'm most humbly praying for not today, my lord.
for not to them. अभी फाइल को जो रिप्लाई तो फाइल में फाइल नो नोट यet नो will not use where is more bathroom.
My lord, I'll inform. My lord.
Witnessed, man. Only thing is that I gather, I am led by Mr. Dastur on this. I gather Mr. Dastur has some difficulty. Well, I'll in February, my lord. Publish. Man.